Good morning, everyone. My name is Dr. Kavita Chawla, and I'm delighted to welcome you all to the Law Conclave 2020, Decoding the Next Gen Legal Professional. We academicians are often blamed for being too theoretical and far removed from the reality of practice. This conclave is an endeavor to keep our delivery of legal education at BMU aligned with the demands of the industry. Very briefly, this conclave is a product of BMU's educational philosophy that emphasizes on practice-based learning. That is, the curricula and learning outcomes in professional degrees should be based on the requirements of the profession. However, a true conceptualization of skill-based learning also necessitates an assessment of the skills demanded by the profession. The legal landscape is constantly evolving as globalization and technology are forever transforming the global economy. The legal profession is also evolving in response to this transformation. The way legal services are delivered has changed, leaving many curious about what the future looks like for lawyers and how to prepare for it. Keeping this in mind, BML Munjal University, along with Vahura, a leading legal recruitment firm, conducted a survey to understand the changing contours of legal landscape from the perspective of practitioners who are an active part of this transformation. Today in the Law Conclave 2020, we will be reflecting upon the insights from this survey. But before we start for the day, I would like to thank all the speakers and panelists who agreed to be part of this conclave and all our guests who are watching this conclave live, both on Zoom and on our Facebook page. Without taking much of your time, I would like to welcome the first dignitary of the day, Professor Manoj Kumar Arora, Vice Chancellor, BML Munjal University, to speak a few words. Professor Arora joined BML Munjal University as the Vice Chancellor 1.5 years ago. Earlier, he had spent 5 years as Director of Punjab Engineering College, deemed to be University, Chandigarh. His peer institute has been IIT Roorkee, where he served as Professor of Civil Engineering before joining as Vice Chancellor of BML Munjal University. Professor Arora holds a PhD in remote sensing from Swansea University, UK. He was a postdoctoral research fellow for about 2 years in a NASA-sponsored project in electrical engineering and computer science department, Syracuse University, USA. He has more than 34 years of teaching, research, and administrative experience in academic institutions in India, UK, and USA. He was the chairman of Regional Committee for Northwestern Region, AICTE, co-chair of Chandigarh State Higher Education Council, RUSA, vice president of Chandigarh Region Innovation and Knowledge Cluster, and member Research Council, CSRI, CSIO, Chandigarh Engineering Evaluation and Accreditation Committee. Professor Arora has earned Outstanding Teacher Award twice at IIT Roorkee, the Commonwealth Scholarship Award, the DST Young Scientist Award, the AICTE Young Teacher Career Award, and Postdoctoral Fellowship Award in a NASA-sponsored project, USA. Over to you, sir, for the welcome address.
Thank you, Kavita. Honorable Chancellor, galaxy of panelists, participants, colleagues, and my dear students. I'm very happy as well as excited about the Law Conclave 2020 being organized by our School of Law, led by Professor Nigam, a renowned academician and a law practitioner. I, on behalf of BML Munjal University, welcome you all to this conclave. A participation of more than 1,000, even in these challenging times, is a testimony of the importance of law education in India. Friends, we are a 6-year-old university, but a progressive one. In this short span, we have been able to cement our place in the higher education under the vision of our Chancellor, Shri Sunil Kant Munjalji, and a very vibrant governing body. We believe in interdisciplinary education and experiential learning with the intent to provide lifelong learning skills to make graduates leaders of tomorrow in their professions, be it management, be it engineering and technology, or be it law. With 4 schools in operation now, the School of Law is the youngest one in the university, which started last year. We are confident that our School of Law is different from other law schools in the country, and there is a reason to say so. Our whole pedagogy is based on the concept of blended learning, experiential learning, project-based learning, learning through gamification and simulations. We believe more in outbound activities, more in practice, as Kavita said, and less in theory. We strongly advocate a competency-based approach where teaching, learning is not solely focused on dissemination of knowledge, but building up of competencies to enhance employability and entrepreneurship through courses such as innovation and entrepreneurship, design thinking, venture ideation, critical reasoning, business ethics, negotiations, problem solving, and intellectual property laws. The BA LLB program has a mixture of economics, political science, and sociology courses along with traditional legal subjects. The BBA LLB program has a mixture of economics, business management, and business administration courses along with traditional legal subjects. The aim of the curricula is to enrich the law students in his or her domain by placing it alongside allied domains with an emphasis on economics and business. The uniqueness is that the students will also learn some of the technology courses to enhance their expertise in the law. As I said earlier, we believe in experiential learning, and our law school has already taken steps to integrate practice elements into the classrooms. In order to deliver this unique way of learning, we require faculty with a different mindset and skills, and therefore we go places to recruit right kind of faculty. Additionally, we have leading professionals and experts coming to our classrooms to interact with the students. Lawyers from leading law firms and academicians from foreign universities have already addressed our students in their classes. All our exams are open book exams which are designed to simulate real life problems. Friends, today we are living in Industry 4.0 era, which is an age of artificial intelligence and data sciences. We as a university has introduced a number of specializations as per the needs of the current era. These include data sciences and artificial intelligence, data analytics, business analytics, digital marketing, Internet of Things, cybersecurity, automation, and robotics. The students can opt any of these specializations as major or minor in their academic program. When I look at 2020 or beyond, it is not hard to find a number of areas of interest in law that are worth looking at more closely. In the context of law and technology, there are three specific areas that I believe will prove to be hot topics for the coming year and beyond. These are cybersecurity and artificial intelligence, data privacy and state laws, IP creation and ownership. I think we should also spend time on conducting research in the field of law and technology that focuses on understanding, interpreting, and critically evaluating the legal impact of technology and technology-based or technology-facilitated processes and behaviors, and also evaluating the potential of technology to facilitate or enrich legal processes or procedures. Further, as we give a lot of importance to innovation and entrepreneurship, and in my opinion, every lawyer is an entrepreneur, perhaps a couple of subjects in this area may also be included in the law curriculum. I believe that our university is rightly placed to impart knowledge, education, training, and certification and do research in these multidisciplinary areas. I'm sure that this law conclave will be able to address rapid technological changes taking place in the legal profession and understand the role of law schools in developing future lawyers. I wish all the participants a very best. Enjoy a vibrant session lying ahead of you. Over to you, Kavita. Thank you very much.
Thank you very much, sir, for your noteworthy address. May I now welcome Mr. Raksha Munjal, President, BML Munjal University, to set the context for this conclave. An MBA from Pepperdine University, USA, and a graduate in BSc Honours in Management from the University of Bradford, UK. Mr. Raksha Munjal joined the Hero Group in 2006. As the President of BML Munjal University, he is the driving force behind this higher education initiative. Prior to his MBA, Mr. Raksha Munjal worked at Hero Mind and Easy Bill Limited, both Hero Group companies. He has also worked with companies such as Accenture, Nestle, and America Honda Motors. He has been an active member of the Rotary Society of India and has also volunteered with the United Nations. I request Akshay Munjal to set the context for this conclave 2020.
Thank you, Kavita. Before I start, I'd like to thank Professor Nigam and his team for organizing this conference. I'd also like to thank the Vahura team for partnering with us for this very relevant conference. As you all know, the pace of change is unprecedented. We are living in times where technology is changing every 5 to 7 years. If you look at history, for many hundred years, the pace of change was much slower. But the era we are in today, there is no aspect which has been untouched by technology. Some professions like education, legal, healthcare, which have been resistant to change so far, are now fully embracing the change. Conferences like these help us plan, discuss, and strategize what is the future and how do we prepare for it. It's all the more relevant and becomes imperative, especially in higher education, where the time it takes when a student enrolls to the time he or she graduates is a long period of time. So, how do we prepare the student for 5 years ahead when there are multiple surveys showing the top 10 hottest jobs which are today didn't exist 7 to 10 years ago? And I firmly believe this will further get accelerated. We will have many new things in the next 5 to 7 years which don't exist today. So I think it's very relevant for all of us together to discuss, debate, and agree or either disagree on what we all feel will the future will be. Especially in the context of higher education, like I mentioned, we have to teach our students today for jobs essentially which don't exist tomorrow. Now, if I talk particularly about legal profession for many centuries was relatively untouched by technology. But in the last 10 years, what we are reading and what we are seeing, that today there is, with the advent of AI, today a machine is able to go through many cases, far more data than it's humanly possible for a human being to do. There are predictions. I've given this example multiple times before. There's a very interesting book called Industries of the Future. The book is now nearly 3 4 years old, written by the former scientific advisor to the Obama administration, a gentleman called Alec Ross. And what he had predicted that by 2030, AI will actually get better in predicting the outcome of cases than human lawyers. And that's just purely because of their ability to read and assimilate a huge amount of data and able to make the connections. Imagine reading all case studies, all case outcomes for the last 200 years and able to put which one is relevant where. And that is already happening. There are many databases today also which are able to do that. Similarly, even in the medical profession, there is prediction by 2030 that computers will be in a better place to predict with whatever data is available to take a more measured diagnosis than what a human can do. Now, if this is the future and this is what is staring at us, how do we prepare for it? We can't wish it away. So it's better that we prepare for the new reality. And like many times in the past, when the first time industrial revolution came, there was a big fear that machine will take over all the jobs. Similarly, with the advent of computers, there was another fear that now computers will replace all human beings. But that is not true. These actually have, with the use of computers and internet, we become far more efficient. We are able to do things which we could not even dream of earlier. Similarly, I am very optimistic and confident with the advent of AI in the legal field, we will be able to do much better than what we are doing. It's up to us how we embrace this tool. It can be a very potent weapon if we use it well. And unfortunately, we don't have a choice. We have to embrace it. With that, as a university, conferences like these become more relevant, like I mentioned. How do we plan ahead? One is planning ahead also to look at what we teach today, look at our curriculum, how we teach the pedagogy, to ensure that we are updated. And if you look at the hallmark of all successful universities globally is that they are continuously adapting, they're continuously refreshing. It's one of those laws of nature. Either you adapt or you perish because things are always in motion. So even for us as a university, these conferences help us plan, go back, strategize, and take all that information and how do we meaningfully integrate into our curriculum? How do we meaningfully integrate with our pedagogy? With that being said, I like to all again wish you all the very best. I'm sure you will find this a very enriching conference. I'd like to thank all the panelists and all the speakers today. There's a wonderful lineup of speakers with very diverse backgrounds. And I'm sure there'll be some very engaging and intellectually stimulating conversations today. With that, I'd like to thank you. And once again, I'd like to thank Professor Nigam and his team. And I'd like to thank the Vahura team for helping put this together. Thank you.
Thank you, sir. It's always a great pleasure to hear you talk. Next, it's my honor to invite our Chancellor, Mr. Sunil Kant Munjal, to give the keynote address of the conclave and to launch the report. Mr. Sunil Kant Munjal is the Chancellor of BML Munjal University and the Chairman of the Hero Enterprise. He has played a key role in creating this unique and transformative higher education initiative in India. He is one of the founder promoters of the Hero Group, India's premier automotive manufacturing group that has evolved from being the world's largest bicycle maker to the largest two-wheeler maker. Mr. Munjal is the chairman of Hero Enterprise, which has interests in insurance distribution, steel making, real estate, and corporate training. He sits on the board of iconic academic institutions like the IIM Ahmedabad, Indian School of Business, Sri Ram College of Commerce, and University of Tokyo. India today chose Mr. Munjal as one of the faces of the millennium for business. In 2016, he won the Jahangir Gandhi Medal for Social and Industrial Peace. In the same year, he was conferred a D.Litt by SRM University, Chennai, and became a distinguished fellow at the Institute of Directors. In 2018, Punjab University conferred on him the Udyog Ratan Award for his role in the state's industrial development. Ladies and gentlemen, I present to you Mr. Sunil Kant Munjal.
Good morning, and thank you for the introduction. My compliments and congratulations to BML Munjal University and the leadership along with Vahura for setting up this very useful and timely event. President Akshay Munjal, Vice Chancellor, Dean Nigam, and friends. It's been said for a long time that the legal profession is one of the oldest in the world. Maybe it is for that reason that it holds on to its traditions, conventions, and culture that it's espoused and practiced for centuries. It is, however, an essential requirement right now that all of us begin to focus on the rapidly changing environment and do the mid-course correction that is required for the legal profession not just to catch up, but to get ahead of many other changes that are actually taking place in the world right now. President Akshay just mentioned about technology that is rapidly changing our lives. And it is true. There is almost no aspect of our lives that has not been affected by technology, which is the reason when BML Munjal University was being set up, we said this will be the most practical teaching, this will be the most experiential teaching, and it will help to build leaders for the future who are well-rounded and complete, not just in the specific course they have taken, but also to be able to lead change, lead in times of uncertainty, and be those who will provide the balanced leadership that the world requires going forward. I have to say with some sense of pride that in 5 years, we have come a long way, and which is why the startup of the law school was a very special event for us. It created for us another opportunity to impact society and people's lives positively. And Dean Nigam, from the day one when he came in, had this missionary zeal to create a law school which would be unique. Like the rest of the university, the mandate here is exactly the same. Let's be practical, let's be experiential, and let's be broad-based while also providing all the depth of the legal profession. And in many ways, that is what the profession needs right now. We do have a challenge in many parts of the world, and more specifically in India, of a massive backlog that has taken place of unresolved cases. It is no one tool that will actually help us resolve this. And we will have to focus on all the tools available to us, creating more courts, creating more expertise, increasing the number of judicial officers, using technology, significantly enhanced forms of technology in managing data, managing cases, keeping records, making previous decisions available, as also alternate dispute resolution mechanisms. There are multiple mechanisms available, whether it's the ombuds machinery, or it's arbitration, or it's out-of-court settlements. I think we need to figure out a way to encourage all of them. It is because of the need that is out there that the initiative like the one that has been taken recently to create a research-based report is very welcome. So my compliments to Vahura and also the team at the School of Law at the BML Munjal University, led by Dean Nigam, for taking this initiative, which will focus on what is it that we need today and what is it we need going forward for us to continue to be in the forefront of the change that is in place. But change not just for the sake of change, but change for the purpose of becoming more effective, more useful, more user-friendly. You know, there are many initiatives going on right now on how do you bring the language, the legal language, to a standard which the layperson actually understand. Because it is a fact today that for almost any agreement that's written, any MOU, any legal draft, you actually need a legal expert to even read them. And that sometimes seems almost unfair because the people who are using it are not always legal experts. So how about changing the language such that any and every person can actually understand what she or he is signing or agreeing to before they actually agree to something? So that when there is an issue, the resolution becomes that much easier and simpler. There is also a need for us to focus on, and this is on the lawmaking side, to focus on making laws simpler so that the interpretation of the laws itself can become much more user-friendly. The entire system, the process that we have right now, is somewhat slow lengthy and can become painful, especially in civil cases where matters can go on for decades. And very often the people who launch the cases are no longer around when the actual resolution takes place. So the question that's been asked often is justice delayed, justice denied? And for that reason, and also to make access easy, we have to figure out a way, for a low cost way, for legal access to be available, quality legal access to be available to all the citizens of the nation. It is also important, as the world evolves and gets closer due to trade, due to technology, due to partnerships, that the understanding of global relations, global trade, the ecology, and geopolitics becomes an important part of the legal profession, which is also why it is important that the legal institutions, legal educational institutions, do not teach only law, but a broad-based education on where law is going to be applied. If law is applied in a manufacturing business, there is an expectation that the legal experts will have some knowledge of the manufacturing enterprise itself. As also, as I mentioned, because the world is getting more litigious, that there is a need for us to create that understanding in the legal profession to be able to guide the users through the labyrinth of regulation that currently exists. We have also found that in many times in our attempt to simplify regulations, we've actually ended up complicating them even more. So it would be wonderful if we can figure out a path where we take the best of all different avenues available to us, which is people's enterprise, their ability to understand, the use of technology, training of people, not just making the availability of top legal experts as the only ones who can provide, they are the fount of knowledge, but within the system, we need to have the ability to handle simpler matters at a level which is far below it reaches the top expertise in the nation and across the world. And arbitration is something that has been discussed now actively for a while. We do have centers in London and centers in Singapore, and now Malaysia is attempting to bring one. It is about time that India also reaches out and builds itself as a center that the world accepts, that global agreements and global partnerships start to look at India as their legal backing source, as the place where they can house their agreements, and as a place where they can come to in times of differences, whether it be by arbitration or by any other means. So once more, good wishes and compliments for doing this wonderful piece of work where many, many users were involved, and the understanding that the digitization and technology is going to change the legal profession dramatically, even within the next 10 years. And also the understanding that even as short a time as 3 to 5 years, things like artificial intelligence will make a dramatic difference. I will close by just quoting an incident that I had myself faced. A couple of years ago, I was at a conference in California, and Vinod Khosla and I were in a dialogue at this conference. So I was questioning him about the progress of machines and technology and what it might do to many jobs. So his question was, why do you actually need jobs? Because the reality today is machines, of course, he was pushing me to the extreme. He did not mean that there will be no jobs required at all, but he said, you have to start thinking about this differently. Why do you need a surgeon? If a robot can do better surgery than almost any surgeon, not take a Sunday off, not be not be in a different mood if the wife or a spouse or a children are not well at home. And I asked him about the legal profession. He's saying, frankly, there is no single expert individual who can gather as much data on historical cases as artificial intelligence and machine learning can. They have to become important tools. They have to become the foundation if not the fount of knowledge, but the foundation on which we will base our legal expertise going forward. We are at this moment facing another challenge through COVID-19, which has put many things on hold, deferred many things, created new situations that were never expected earlier. So the legal profession needs to be able to respond quickly to situations that get created as well. And I hope and wish that the highlights of this report will get used by those who train, those who teach, and also those who practice. So once again, thank you very much. Good luck and good wishes for this seminar, which I see the conference has a wonderful set of sessions and speakers. I am certain that all the participants will benefit from it. And we as an institution would like to keep ourselves open to all these connections and relationships that we create, so that you can come back to us again and again with ideas, with suggestions, and with partnerships. And we would gladly look at doing things together rather than only by ourselves. Good luck and all the very best.
Thank you, sir, for your keynote address and for launching the report. I'm sure the students and lawyers will immensely benefit from the observations and suggestions made by you. And once again, thank you on behalf of the entire team. Let me introduce this conclave. This idea was this BML Munjal University in Vahura, a leading legal recruitment firm, conducted a survey to capture the practitioner's perspective of the practice of law and the skills that are required by lawyers in this rapidly transforming legal environment. In total, 208 legal professionals from leading law firms and in-house legal departments, as well as the independent practitioners, they shared their perspectives on the impact of technology on the legal profession and the skills and attributes that are required for the next generation lawyer to survive in this current legal ecosystem. BML Munjal University and Vahura together curated this research in the form of a report titled Decoding the Next Gen Legal Profession. The results of this survey were analyzed in depth, and Vahura and BML Munjal University will be discussing, the representatives of Vahura and BML Munjal University will be discussing the survey's insight in detail. Mr. Ritvik Lokus is a corporate lawyer turned entrepreneur. He is a graduate of the National Law School of India University, Bangalore. After practicing in Mumbai with the leading corporate law firm, Ritvik began his entrepreneurial journey in 2007 to co-found ventures in talent management, online learning, and the consulting domains. Ritvik has since exited his other ventures to co-lead Vahura and counseling. Ritvik is also a trained mediator and an advisory board member of the CAMP Arbitration and Mediation Center in Bangalore. I now request Mr. Ritvik Lokus to share findings from the report. Over to you, Ritvik.
Thank you, Dr. Kavita. Before I begin, I'd like to thank the School of Law, BML Munjal University, for commissioning the study. It's a very important and timely study that we've undertaken. And for anyone who's joined us from the beginning, I think the context has been set wonderfully by the Vice Chancellor, the President, and the Chancellor in setting the context from a broader scientific, business and technological perspective. And what's interesting, I think, with this survey is that usually there's a perception that lawyers are, in a sense, in denial about what the future holds. From the outside, I know it can seem like the legal profession is stuck in a different century. Both visually, if we look at the media and how society looks at the legal profession. What we'll find in this survey, and this survey, we use a survey approach for this study. So this survey went out in June the survey went out in June 2020. It went out to over 2,000 professionals. We targeted mostly senior professionals who are in some decision-making capacity to hire or in a management role. It went across the profession. So law firm professionals, in-house corporate counsel, independent practitioners, new law professionals as well. So folks in legal tech, 208 professionals took the survey, and I would like to thank everyone who took the survey for spending the time. So we're going to divide this presentation in two parts. I will take the first part, which will focus on the technological impact on the legal profession. And then I will invite Dr. Nigam, who's the Dean of the School of Law, to take the second part that will focus on skills and education. So let's dive in. Who took the survey? Over half the respondents were from law firms in India. About 1/5, 20% were in-house legal counsel. We had a good representation as well from independent practitioners, as well as other members of the legal profession. So it's like, for example, from legal technology, from alternative dispute resolution, alternative service providers as well. The three broad meta responses that we got all point to what Mr. Sunil Munjal spoke about, which is that we're living in times of change. So 91%, almost everyone who took the survey acknowledged the fact that there is an increasing use of digitization and legal technology. We'll dive into that a little bit more in the future slides. The other two aspects are also important because they set the context. So the second is that the law firm domain is becoming increasingly competitive. In a sense, the golden years of the 2000s and anyone I started in the profession in 2004 in a law firm, and very often when we talk to other lawyers, you keep kind of harking back to that golden age, but that golden age may have passed, and we live in a different time, and that really kind of also points out to the third point, which is 50% of respondents also acknowledge the growth of in-house legal teams. What we'll also see is that much of the change and much of the technological adoption is also being driven not just by practitioners, but also by clients. And in this case, the clients are corporate counsel in in-house legal teams. So 55% of the respondents believe that technology disruption is already underway, or it's bound to happen very soon. 50% of law firm respondents, if we break this down in terms of where the respondents come from, 50% of law firm respondents believe that up to 20% of their day-to-day work will be automated. When we come to in-house respondents, 67% of in-house respondents believe that 20 to 50% of their day-to-day work will be taken over by technology. Now I'm going to just correlate this to another study that we did at Vahura. In April 2020, we ran a survey with general counsel. So general counsel are the heads of legal function within corporations. And in that report, we had about 100 GCs take that survey. And what we found is that in the next year, 67% of the general counsel reported an increasing use of legal technology. So this percentage that we've cited in this report is in fact corroborated in the GC survey that we've also already undertaken. Now, when we come to independent lawyers, 40% of independent lawyers believe, again, that up to 20% of their day-to-day work will be automated. So what this points out to is that within the legal profession, the tech disruption has certainly moved from the fringes to the mainstream. And this has happened certainly at the mental level and in terms of accepting that this change is there. In the panel discussions that we will have coming up after this, we'll also get an insight as to how much of that has practically moved on the ground. And we have some interesting examples coming up both from the in-house world and law firms. At this point, I'd like to take a moment. We've been talking about technology, and it will be good for us to really break that down and look at the levels of legal technology. So we've broken this down really at basic, intermediate, and advanced. Basic technology is something that all of you will be using now. All of us are using. So the tools that we use to do our work, so Word, Excel, legal research tools, like Manupatra, LexisNexis, SEC Online, also document management, case management systems to manage information. So that's something that's a part of all our lives already. The intermediate level, maybe there are early adopters among us, and it's moving from an early adoption stage to an early majority stage. That's a diffusion. There's a curve that describes the diffusion of innovation. So at the intermediate stage, it's really about document automation, or also using rule-based data retrieval systems. For example, there are tools out there that can crawl through systems like, let's say, the ROC database, or another government database where compliance filings are made, and can pull out information, and that information is organized. Or it can be an expert system, which is basically a rule-based system. Certain rules are inputted, and the system will apply those rules. So there are compliance systems that, for example, are rule-based. So many practitioners, I think, who are watching, especially with in-house legal teams and some firms, will be more familiar with the intermediate level. Both the president and the chancellor also spoke about artificial intelligence. It's something that is part of our daily lives today. If we're using Google Translate, if you're using now when you're typing an email, the email finishes sentences for you. So it's certainly a part of our daily lives. In the legal world, there are tools out there, and we'll spend some time on it in the panels as well. But I think, at least from an India context, it may be still at an innovator stage, and still at adoption levels are fairly early. So this brings us to the question, especially if you're a law student or a young lawyer, the big question: will robots replace lawyers? And here I'd like to cite Professor Mary Sacco from the University of Oxford. She and her team have done some pioneering work on looking at AI and the legal services delivery model. And what Professor Sacco says is that AI will replace some tasks, not necessarily jobs, and that's an important distinction. And AI will replace tasks that are repetitive and scalable tasks. But AI will also augment lawyers, and this augmentation will happen in a couple of ways. One way is where AI will augment the lawyer as a consumer. So when a lawyer is providing advice to the client, the artificial intelligence tool is one of the tools that the lawyer uses in providing that advice. In the middle, yes, there's some work, repetitive and scalable tasks that will be substituted by AI. And at the other end of the spectrum, what we'll see is where lawyers basically augment artificial intelligence. An example of this, and these are tools that are currently available and being used. There are AI tools that if a company, let's say, provides all its contracts to this AI tool, the AI tool will analyze all the contracts for certain continuing obligations that are there. And the artificial intelligence tool may take that analysis up to 97%. But the balance 3% is done by a team of lawyers and other professionals that ensure that that final work product is what is ready for delivery to the client. So the related aspect here is all this change and this impact of technology also means that the legal ecosystem or the legal ecosystem is changing. So, maybe a few decades ago, the choice for a client, and here I'm referring primarily to a corporate client, the choice was, do I go to lawyer A or do I go to lawyer B? In the last 10, 15, 20 years, the choice has been more about, do I go to law firm A or do I go to law firm B? So now that choice is changing. That choice is increasing in many ways, and I think this visual, uh, provides some insights into that. So one is that, as we saw in the first slide, the in-house legal teams itself are growing. So a lot of the work that would go to a law firm or an individual practitioner is now being done by the in-house legal team. We also see the rise of alternative legal service providers. We also see LPOs, legal process outsourcing companies. Then we see legal tech companies that will provide a product or may provide a service as well. And the law firms are very much, at the pinnacle of this ecosystem. But within law firms also, we are seeing segmentation. So you will see large law firms, boutique specialist law firms, regional law firms. So each firm and segment of firms is finding their own niche. And lastly, the big four consulting firms have been also entering the domain that was traditionally occupied by law firms. So we're seeing, so the client choice has become a lot broader. And as you will see, these circles are overlapping circles. They're not independent. So you will see law firms investing in legal tech, big four investing in legal tech. So we're seeing both segmentation as well as collaboration. So where does that leave lawyers? Number one, like I mentioned, law firms are starting legal tech engagement frameworks. In India, we have a few good examples as well. So, for example, a Trilegal is involved with Agami and the Agami initiatives, which I'll come to later. Srila Merchant Mangaldas has set up an incubator. Algo Legal, and we have Sandeep Kapoor from Algo Legal joining us for the second panel. Algo Legal also incubates legal tech startups. Other firms like Samvad are involved also with sister ventures on focused on ODR. Second is in-house legal teams. We're seeing an evolution with in-house legal teams where there are new roles coming up. For example, operations teams. The chief legal, the legal operations role is becoming a new role that we're seeing here in India as well. Third, and Mr. Sunil Munjal spoke about ODR and e-courts. We're seeing increased adoption of ODR. We'll talk about that in panel 2. Fourth is the legal tech ecosystem. And I mentioned the Agami Prize here. At Vahura, we're one of the founding partners of Agami. The Agami Prize is an initiative to recognize the best in not just legal tech, but in providing innovative solutions in the citizenship space to industry as well as early stage ideas. So the Agami Prize is on and closes on July 31st. We'll talk about the legal tech ecosystem in panel 2. And lastly, like I mentioned, we will see new roles and new opportunities. So legal operations, legal project management, analytics, legal technology, innovation teams are now developing within law firms and in-house legal teams as well. So there, I think with every change and with every introduction of technology, there are new opportunities. Yes, there will be areas that will be automated. And it's important, I think, for all of us to acknowledge what those are so that we can plan for the future. And I'd like to end my section of this presentation with just talking about where we are today, because there are many of us from the legal community on this webinar, and the last 2 months have been very difficult for our friends who are litigating in court and our friends who have cases in court. And the COVID-19 pandemic has just made it so clear that we lack technology, and some of the rules and processes that are there are need to be upgraded and need to move with the times. So I will pause here, and I'm delighted to be able to introduce Dr. Nigam. Dr. Nigam is a fellow alumnus from the National Law School. I've had the benefit of being his student, his first batch, where he taught at NLS. So Professor Nigam did his LLM in tax law from NYU, and his doctorate in philosophy from Oxford University. He's taught at NLS. He was also taught at the Azim Premji University for the inaugural LLM batch. And delighted that he's the dean of the law school at BMU. And exciting times for the law school. And Professor Nigam, I'd like to invite you to take the second part of this presentation.
Thank you very much, Ritvik, for that introduction. Can we go to the next slide? Yeah. So thanks everyone, and a very good morning to everyone. In some ways, this is one of the most exciting days for me since I joined the law school, because it's a culmination of a series of conversations that I've been having with a number of people over the last 1 year, and that to me is really the most important part of this conclave. That its conclave is just one day, but it's actually a result of a series of conversations over a period of time with people from various modes of careers and lives. This entire idea of inviting lawyers to tell us about legal education, which looks to me right now as something that ought to have been done years ago, is something that came out of a conversation I had with the Chancellor and the President, who were very keen when I joined this law school to align legal education with legal practice. Now, as I said, as I'm saying it to you now, it doesn't look like it's a very radical idea. In fact, probably should have been done years ago. But our legal ecosystem is in a very interesting space right now. For years, it's been the case that law schools are living in an island of their own, and their idea of what legal education is has in some ways atrophied and has not kept in touch with the legal realities and with the realities of the marketplace. And I think that's something that really needs to be remedied. It's a systemic issue for us. It's a systemic issue that legal education has not taken account of the kind of skills and trends that are available in the market. And that is a major problem, I think, for any law student who goes to law school today. I mean, I think Ritvik always makes it a point to tell me that what I taught him is actually outdated in multiple ways. I taught Ritvik. I'm proud to have been his teacher, nearly 20 years ago. And when I taught him indirect tax, there was no GST. There was only excise tax and sales taxes. So substantively, things have moved on, and then procedurally, things have moved on as well. There were at least not the kind of legal research skills that we have now through Manupatra and LexisNexis and Westlaw and SEC Online, all the things that Ritvik actually put in the basic bracket, not in the, he had 3 brackets in this previous presentation. And one of them, it started with basic, intermediate, and advanced. And I was shocked to note that he has put legal research skills in the basic bracket, which was not even there when I was teaching Ritvik. So if you can see on the slide, and you can see how the extent to which things have moved on. That what was considered revolutionary, say 10 or 15 years ago, is now in the basic bracket. It's not something that you have to have. And I just wanted to make one more point about that. Ritvik, sorry, if you could just go back to that basic bracket. I just want to make one more very interesting point that came to my mind. It's interesting that Ritvik has put, in addition to Word and PDF, Excel and Excel sheets knowledge, something that lawyers rarely learn in law school. In fact, I don't think there's any major law school that actually teaches Excel quite seriously. And then we find out when we go to any reasonable corporate practice that a basic understanding of Excel, and in fact an advanced understanding of Excel would be even better, but a basic understanding of Excel is required for every lawyer. So yeah, Ritvik, now I think we can go back to the slides. So I think it's really important for us, therefore, to understand how to align legal education with legal practice. And so when we went on this survey, we were very keen not only to ask how technology has changed legal practice, but also ask lawyers, what does it mean for legal education? What does it mean? What do you require of young lawyers entering the profession today? Right? And any thoughts and comments and decisions that we understood through this survey is crucial to us as a feedback mechanism for us, right? And this feedback mechanism, I think, should be there at not just at the law school level, but much like at other schools in our university, it is there at all stages in all schools of the university, whether it be management or engineering, that we need to seek feedback from the real world, from the practice world, in order to figure out exactly how we train our students. And here I should take just a bit of a break, if you can indulge me, the audience, and talk about the very purpose of a law school, right? So there's a great divide in the philosophy of legal education. On the one hand, a lot of legal education inspired by what happened in the UK and in America is considered as giving a broad liberal-based knowledge to students. That's one of the main motivations behind the BA-LLB integrated course started by Dr. Madhav Menon in the 1990s, of which I am a product, and Ritvik is a product, and many of the panelists here today are products. So that kind of the integrated 5-year BA, LLB, and of course now it's become BA, LLB, and then other BSc, LLB, BBA, LLB, etc. But the BA, LLB was the kind of model on which plenty of other law schools have been built after the 1990s. And one of the primary motivations behind that model was to give every lawyer a broad-based legal education, right? An education that situates the role of law in the wider context of liberal arts, be it economics, be it political science, be it sociology, history. I'm giving you a catalog of subjects that I learned when I was a student in the 5-year integrated program, and it's the same thing 25 years later. Our students at the law school that we are building and the law schools elsewhere are learning the same catalog of subjects. They're learning in the first 3 years of their life, they're receiving a broad-based legal education. Some reason that philosophy that illuminated the 5-year program seems to have taken a life of its own and seems to have dwarfed the other major reason law schools are there for, which is to inculcate important legal skills, or if I may call it, skills that are relevant to the legal profession for lawyers. So in other words, it is in some ways, some people feel that the liberal education or the background of liberal education that permeated the 5-year program is at variance with the idea of skills that legal skills that students have to learn, and that the BA LLB course is for the students to learn about life and about poetry and about allied subjects like history, economics, political science, and then they start learning about practice when they go actually into practice. And I think that's not the right way of looking at it. I think the BA LLB course, whilst providing a very important liberal understanding, situates the law students in a situation or in a place where they also have to learn, in fact, as an integral part of the program, important skills that they need to take forward in their legal practice. Right? It cannot be that the law students depend on learning these skills only when they enter legal practice. I mean, legal practice teaches very important stuff to law students, but it cannot teach them basic skills on their own. The skills that are required, some of which we'll be talking about in today's presentation as well as in the panels that follow, are skills that have to be learned when you're in law school. Otherwise, it gets not just difficult, but almost impossible, virtually impossible for the law students to develop into successful lawyers. So this divorce of sorts between liberal arts education, which permeated the 5-year LLB course, and skills-based education, I think is unfortunate. And I think one of the reasons, one of the insights of the survey is that we must bridge that gap, that while the BLLB 5-year course is an important liberal arts introduction to the law, it must also contain within it a mechanism to teach important skills to the students. Now, and that's what we'll be talking about for the rest of this presentation. So when we took this survey, what we asked them was, you tell us what successful young lawyers need to do, right? Somebody entering the profession. We understand that a lot of things you learn when you enter the profession, you cannot learn it unless you have done some practical work in a law firm or in litigation. So it happened to me as well. I mean, when I went to my formative years of legal practice were in New York. I worked at an international law firm in their tax department. It was a trial by fire for me in some ways. I was just fresh out of law school, and I went to the LLM tax program at NYU, and then I had to, immediately after that, work on really kind of complicated international tax matters where I had to give opinions to people. And so the things that I learned that were important for me, and I couldn't have learned it unless I actually practiced. But there were other things that I think I could have learned while in law school that would have helped me in my legal practice. So when when Ritwik and I were talking to law firms and asking what kind of skills you require, we noticed immediately that there is already there a mix of what we might call traditional skills and what we call so-called new age skills. Right? That, I mean, I don't think they are so new age. I think they've been there for a little bit of time already. But let's, for the purpose of discussion, divide that into traditional new age skills. So as you can see on the slide, 94% of the participants have been talking about traditional skills. They've been saying research and analytical skills are important. That's what you need to learn in law school. So if you want to learn, if you have an issue, legal issue, you need to learn how to identify a problem, a legal problem. You need to identify where to go searching for solutions to that problem, and you need to know how to analyze those solutions. This is fairly traditional, mainstream, almost Bloom's taxonomy kind of pedagogy. And that's still very important, right? So we need, and that's what happens in the first few years. You need to learn research and analytical skills in any subject, and it's been taught, it has to be taught at law schools. But what's I think not taught very well, and this is what came up in our survey, is the attention to detail and the accompanying oral and written communication skills that are important. So it's important, therefore, that we make sure that students acquire the opportunity and the means to become detail-oriented. No high school student comes into law school with detail orientation. It's a skill that needs to be taught, right? And so in order to ensure that you go through all the provisions of the statute that are relevant, lay them out in proper order, and then you're able to state a solution for each of the issues that you have identified, is a detail orientation that you learn when you go to law school. You don't learn it before you go to law school, right? I see that on a day-to-day basis when I'm teaching my students. I just taught a short GST introduction class to students at the university. And the first thing, when I give them a problem, the first thing they do is they give me a solution as if the solution has come out of nowhere. So if I tell them what is the tax on this particular transaction, they say the tax must be this. And so I tell them that's not the way to answer the question. For every legal question, you must start with the legal provisions. You have to go to the statute, identify the statute and the statutory provisions applicable, and then try to lay a thread from there to the facts that are given you on hand. And that's the kind of, what I say, detail orientation that really comes out of training. And that's important. I think it's not just knowledge dissemination that's important, or it's not just mere basic research and analytical skills that are important, but we need to pay attention to detail. See, an aspect that appears almost ordinary, right? You better be careful, is another way of putting it, but it's something that I think a lot of young lawyers and certainly law students miss. If you, Ritvik, can we just go ahead, please? So the other interesting thing that came out of the survey is the situating law in context skills that were important for law students. So the two really important skills that the survey came up with was that the lawyers should be able to understand and anticipate client needs, and that commercial awareness is an important skill for lawyers. This is something that I think is crucial for all law students, because unless they understand the law in context, they will never be able to solve a legal problem. But how do we even translate what I've just now said into a practical legal education model is a challenge, right? So take a simple example. If we are talking about contracts, we don't start with the Contract Act or the provisions immediately. What we start with are the kind of business issues or commercial issues that the contract is trying to solve. So I start my contract law classes by telling people, my poor students who are already puzzled by me, I tell them contracts is for allocation of risk. That's what contracts do. Forget about the Contract Act for the time being. Think about a contract as a means to allocate risk among parties. And then I give them a practical solution, a practical problem. I tell them, look, we are talking about entering into a contract, a long-term contract to build a bridge or to develop a building. And then what are the risks involved with respect to this contract for either of the parties involved in it? There could be price escalation, there could be labor strikes, there could be some delays by one of the subcontractors. How do we ensure that the contract provides for this risk allocation? And it is in this context that we are talking about ensuring that the Contract Act regulates this behavior in a certain manner, right? If we don't understand the context for the Contract Act, there's no point understanding the Contract Act, right? So this idea that you need to anticipate client needs and the idea that there has to be some kind of commercial awareness is an idea that is at the heart of how to practice law successfully and in a relevant manner. In fact, the BLLB course or the BBLLB course has got means at its disposal that are especially relevant to this issue. And so we have our students learn economics, learn business, learn management, learn some part of legal history. And all of these are relevant in understanding law in context, right? In understanding a problem first, and then understanding how law relates to that problem. One of the partners in my law firm, when I first started out in New York, told me that every good lawyer reaches a stage in their lives where the law kind of fades away to the background. Right? And what's really important is, as a business matter, what needs to be done. And what he meant was not that we ignore the law, but that we work in such a way that we now enable the law to solve corporate problems. In his case, corporate problems. It could be used in any other context. Right? And that's a very interesting way of putting it. That the law kind of, for a good lawyer, the law is the scaffolding in which you're able to build something for your client. And that's what we mean when we say, how do we anticipate client needs, and how do we understand commercial awareness? Next slide, please, Ritvik. Thank you. So the following on with that idea about skills and commercial awareness and client needs, the report mentioned that we need direct practical application, some practical exposure, contract drafting, pleadings and procedures, while at the same time prioritizing the fundamentals of law subjects. All very important and relevant stuff for law schools. As I said, research and analysis and fundamentals of law subjects are really important traditional issues for us. But in addition to that, we need to ensure that we increase the commercial awareness of our students, and as well as the ideas of a client needs, by giving them an experiential learning education. We already do that at our law school. We certainly see that in many other law schools as well, which is that in every class or in every course, the practical elements of the course are integrated into what they're doing. Contract drafting, pleadings, procedure. Those are just examples, by the way, from the survey. But we could talk about the same thing in almost every constitutional law, which is the great liberal domain of the law, still involves some practical application and some experiential learning. And we are planning to invite lawyers, constitutional lawyers, to our constitutional law classes in order to ensure that they don't just hear about Article 14 and Article 19 and Article 21 in the abstract. What they do is they hear about it through lawyers who might have actually worked in those areas. So it's really important that we have that kind of practical application. Next slide, please. So how do we, and this is something I think that we'll continue talking after my presentation in one of the panels, but how do we operationalize what I've been talking about, what the report has been talking about, right? And there are a few pointers here that I wanted to present to the audience, and certainly we can, each of these can be taken forward in greater detail in the panels as well as later on in our conversation. And you can see we need to design courses to develop critical techniques, right, to question why a phenomenon is the way it is, and enable students to evaluate alternatives. So again, my poor first-year law students, I make them suffer a bit in even what they might consider as a relatively easy course. So they go to tort law and they say the tort law is full of very interesting cases. Let's have a little bit of fun. Then I say, yeah, let's have fun, but let's talk about why tort law is what it is. I mean, why is it that people are punished for negligence? Why is it that a negligent person has to be punished? I mean, some people can't help being clumsy. Some people can't help not paying attention to things. Why is it that the law says that if they do something wrong, they need to be punished for it? Why should they pay compensation? Right? So we start off with the Donovo versus Stevenson case, and we say, why is it that if you find a snail in your can of a soft drink, why do you need to hold the can manufacturer responsible when it might well be that it was just bad luck. Right? And since we start, but you see, we ask that question because we want the students to understand and debate ideas of responsibility and fault, and in fact, ideas of blame. And then we ask the students, can we do something different? Do we think that tort law always has to be about responsibility and fault, or can it be about no fault tort liability? So we go into no fault insurance for in motor vehicles, and we say, look, why can't we have that paradigm or that model? You consider the alternative, right? And we do that in the first year, right? In the first few weeks of the classes. And we do that because we don't want them to think, as many high schoolers are prone to think, because of the way our education system has progressed, that there is a clear-cut answer to everything that they just need to know, and then their life is going to be sorted. We don't want them to think that way, because in law, certainly in areas of law like tort, there are no clear answers. There are problems and there are alternatives. And it's important that lawyers understand, the law students get the ability to understand what that alternative is. And there's no point teaching them in that fashion unless we then start designing assessments where we ask them to solve problems and address challenges, right? So this is where we make sure that we kind of take forward that conversation that we have been having into the exams as well. And we build assessments that help students address different perspectives and complex problems in law and society, right? And these assessments, therefore, are complementary to what we are trying to do in critical thinking. And the critical thinking is complementary to what some of the issues of the survey have said, which is that, of course, you need to know the fundamentals of the law, but we need to go ahead. We need to have some kind of awareness of the different kind of issues that are at the heart of legal problems. The next slide, please. So my view, and I think it is shared by the rest of my faculty, is that the law curriculum should help students think deeply about meeting law and policy challenges, and through relevant electives, and this is how we can take advantage of the multidisciplinary aspect of our university. The law curriculum should enable students to understand coding, drone technology, AI, blockchain, biotechnology, etc. Right? And the whole idea for doing all this is because law students should be able to translate new problems into traditional legal issues. Right? So a traditional legal issue is somebody has an accident, who's responsible for it. The new problem is that there could be a driverless AI-powered car that is the cause, immediate cause of the accident. And so we translate those traditional legal issues into, we translate new problems into the traditional legal issues. So the idea of responsibility is not going to go away. Right? The idea of responsibility in the law, whether it is tort law, criminal law, contract law, it's not going to go away. There's a wonderful course that I did as a part of my my BCL at Oxford, which I think is loved by most of the people who did the program there. It's called the Philosophical Foundations of the Common Law, and at that point of time, it was taught by a famous professor called John Gardner, who sadly passed away recently. And we could see when we did that course that how some ideas permeate or trespass across different domains of the law, and it's up to the student to figure out how those domains are connected with each other because of those issues. So the idea of responsibility is an issue which permeates contract, tort, and criminal law, right? And it is up to the student to figure out how to synthesize these concepts across these domains. Next slide, please. So in addition to talking about how students should conceptualize law and how they should have critical thinking, I think that the law curriculum, following on from what has been stated in the Vahura BMU report, holds students accountable for deadlines on papers and essay submissions, conducts frequent examinations, and has strict requirements and deadlines on internship and placement application and processes. I call it the skill of effectiveness. So I have written a piece on legal education that says that, of course, there are skills that are important for lawyers. They have to be able to communicate effectively. We have been talking about that. They have to be innovative. They have to be empathetic. They need to understand what it means to work in teams as well as contribute to each other's success. But in addition to all that, they also should have the skill of being effective. It's a skill that is missing, I think, in a lot of lawyers, in fact, a lot of professionals, and I would say a lot of academics as well. Probably academics are the most culpable. What we're trying to do, therefore, is we're trying to solve this last mile problem. We're trying to say that there's no point of a student being skillful in communication, and being innovative and being knowledgeable, if he or she is not able to complete tasks that are given to him on time. Time management is important. And we kind of make sure that, and that's what we should be doing. I think all law schools should make sure that this idea of time management, the rigor of the law school process, is maintained throughout. I've mentioned in one of my writings that one of the early success of the National Law School in Bangalore was that all students had to complete 60 projects over 5 years. They're basically doing written assignments every 6 weeks. It was a treadmill. It was something that had to be done, and there were deadlines there for every 6 weeks for the students with no respite in sight. So it was, and I think that really helped hone the skills of law students and made them aware of the importance of sticking to deadlines. And these are almost what you might and I might call trivial matters that actually make a huge difference in the end. And as I said, all of us are culpable of not doing it. So we might be not doing what we are asking other people to do. But it's a really important skill, though. It's an important skill to be able to stick to deadlines and time management. And that's an important skill that should be taught, and not taught when you start practicing law, should be taught right over the 5 years of the law school. Next slide, please. Right. So here we come to this idea that the idea that the traditional skills, which are in the T-shaped paradigm that we're showing you, is the straight line, and then there are the non-traditional skills, which is the line parallel to it, and we notice it is important. It is not that we are doing away with the idea of fundamentals of law and drafting and negotiation and research and analytical skills, but it's equally important now to look at project management skills, technological proficiency, time management, skills of the sort that we would have thought is something that the student has to learn when he starts practicing. It's up to the law firms or the litigating lawyers or others to teach the student. And we believe that that's no longer the case, that law schools, through their curriculum and their pedagogy, have to also address maybe not all of these skills, but at least a substantial part of these skills have to be addressed in the law school itself. I have mentioned 4 of them in some of my writings. I think communication is key. I know that one of the participants in the panel that will come later to Dr. Guru Swami believes that it's really important for lawyers to write clearly and precisely. That skill is very important for her. She believes that that maybe other things can be taught, but that skill of getting her ideas across is a skill that needs to be learned systematically right from the first year of law school. Similarly, law schools, the students should actually learn to be innovative. I gave you examples. I said talking about responsibility, talking about allocation of risk. The students must be ready to have some, because everything that they come to life later on will not be from a textbook, and therefore they have to learn to be innovative in their thinking and applying traditional legal concepts to new situations. They have to be empathetic. They must become constitutional lawyers, not just in principle, but in practice. They must learn or imbibe the idea of equality and fairness. And last but not the least, they must be effective. right? They must be able to ensure that what they set out to do, they actually do it, right? And that's not something you should wait until you go to a law firm or to a litigator's office to learn. That is something that you must start thinking about right from the beginning of your law school. So thank you very much, Ritvik. I think we have come to the end of the presentation. I just want to leave you with the thought that we are at a stage right now where I think for the first time, law schools and law universities are trying to figure out what we need to do to our syllabus, our curriculum, and our pedagogy in order to be better aligned with what we want our lawyers to be. And I think the BMU Vahura report is an important step in that direction. I want to end this presentation by thanking the president, the vice chancellor, and all my team members who helped me conceptualize this idea and implement it. And I also want to thank Ritvik, who, after having suffered through my classes, still had the courage and the grace to come and work with me again after all these years. So thank you very much, and over to you, Kavita.
Thank you, Ritvik and Professor Nigam, for sharing the findings and insights from the report. Next, we have some very interesting discussions lined up for you. Our first panel discussion for the day is New Age Skills for the Legal Profession. The last couple of decades have witnessed an evident transition in the ways that lawyers and courts operate. The technological advancements are not just creating new possibilities of delivering legal services, but also affecting how society and businesses operate, and thus changing the law substantially and procedurally. The ever-expanding commercial activities have resulted in an increased regulation of our social and economic lives. The number of special laws and tribunals have been continuously increasing, and the trend is likely to continue in the foreseeable future. Increasing globalization is giving rise to legal disputes involving multiple jurisdictions. Lawyers are not just arguing in courts and overseeing transactions. Increasingly, they are expected to facilitate alternate dispute resolutions. The question that arises then is, how can we prepare our law students to develop the ability to fit into this continuously evolving legal landscape? Is it enough to teach them legal analysis using case laws, or are there any other skills that law students must acquire? In this given context, the panel will discuss the importance of skill-based legal education and suggestions for law schools to adapt in the new expectations. Joining in this discussion today, we have, in alphabetical order, Dr. Menika Guru Swami, who is a senior advocate at the Supreme Court of India. Dr. Guru Swami, through her litigation practice, has successfully sought reform of the bureaucracy in the country through a fixed tenure, defended central legislation that mandates that all private schools admit disadvantaged children, and most recently overturned Section 377, the colonial era law that criminalizes consensual same-sex relations. Dr. Guru Swami is amicus curiae appointed by the Supreme Court in a case concerning 1,528 alleged extrajudicial killings by security personnel. In a private law practice, she litigates in the area of civil law, commercial law, and white-collar crime. Dr. Guru Swami was educated at Oxford University, Harvard Law School, and the National Law School of India University. She is a Rhodes Scholar at Oxford, was a Gammon Fellow at Harvard. She's been a visiting faculty at Yale Law School, New York University School of Law, and University of Toronto Faculty of Law. Our second panelist is Mr. Rajiv Luthra, founder and managing partner of LLN Partners. Mr. Rajiv Luthra has taken his firm from a single person to being one of India's preeminent top-tier corporate law firms since its inception in 1991. Mr. Luthra was recently recognized as leader for project finance practice by Who's Who Legal 2020. He has also been inducted in Hall of Fame for Corporate and M&A India by Legal 500 220. Mr. Luthra has featured in top 35 legal icons India by India Business Law Journal. He is also recipient of the National Law Day Award bestowed upon him by the Honorable Prime Minister of India and the Chief Justice of India, and the Managing Partner of the Year 2020 award by ALB India, among several others. Our third panelist is Mr. Shubha Mandal, who is the Group General Counsel of Tata Sons, the principal investment holding company and promoter of the Tata Group. He is a director on the boards of Tata Group companies and member of the CII National Committee on Regulatory Affairs. In 2020, the Chambers awarded him Outstanding Contribution to the Legal Profession in-House Award. In 2019, the Chambers also recognized Mr. Mandal in their list, the most influential general counsel in India and the GC Influencers Global 100. In 2019, the Financial Times London rated him amongst the top 20 global general counsels, the first Indian GC on the list. In 2015, Mr. Mandal was selected by the Economic Times Spencer Stuart in the prestigious 40 under 40 list of India. Our fourth panelist is not only the Dean School of Law, BML Munjal University, but also my boss. May I please have the honor of welcoming Professor Nigam to this panel, who holds a DPhil from the University of Oxford, an LLM in taxation from New York University, and a BA LLB honors from the National Law School of India University. Professor Nigam was previously a visiting professor at the National Law School of India University, Bangalore. He has also taught as an associate professor in the School of Policy and Governance at Azim Premji University, during which time he headed the university's newly founded LLM program. Before joining academia, he worked as a tax lawyer in New York and is a member of the New York Bar and the Indian Bar. Moderating this session for us is Mr. Kian Gans, founder Legally India. Kian is the founder of Legally India, the first website regularly covering Indian legal news and affairs in real time since 2009 till now. He studied law at Oxford University and has worked in the UK and Europe with top international law firms. Kian was a legal journalist with the Lawyer magazine in London. Thank you everyone for joining us today. Over to you, Kian, to take this forward.
Thank you, Kavita, for that introduction. And I would like to welcome all of the panelists also. We've got a really star-studded, excellent session ahead. I'm not sure if everyone is dialed in right now, but if you can enable your videos also, that'd be great. In any case, let me also start out in sort of alphabetical order, because we have a lot to cover today. And I think we have a lot of different viewpoints also that we want to accommodate and share. So first of all, I think Dr. Menaka Guru Swami has already been introduced, and she's done some of the most interesting work in the Supreme Court and in academia as well. She's worked in the US and she's studied at NLS as well. So she has a very unique perspective on how the bar and academia sort of interact. Menaka, are you there?
Yes, I'm here, Kian. See you and
hello.
hear you well, and it's nice to see you.
So I would like to start perhaps by addressing the bar. I think can be incredibly meritocratic, right? On the other hand, it can also be a sort of area where you do often, it's said, need a godfather to be able to succeed, or a godmother for that matter, or other extra legal advantages of families who've acted in courts before, or judges who you're related to. What would your sort of perception be about success at the bar? What kind of skills does a young lawyer need? Is it possible to make it purely on merit, or what does merit even look like in this sort of context?
Well, thank you. First, I want to start by saying that thank you to the university and to my friend and classmate Nigam from organizing this. It's really nice to see everyone, and I really mean this because as legal professionals, we're quite social here. And one of the things the pandemic has done is that we don't really meet physically anymore. So it's nice to see Mr. Luthra, it's nice to see Shiva, who apparently has not aged a day, may I just say. He looks exactly as I remember him from NLS. So it's wonderful to be here. My parents are absolutely wonderful people, but they're not lawyers. I don't have family lineage. at the bar or on the bench or what have you. I really enjoy the practice of law. I'm a woman, and when I first started practicing law, it was you hardly heard a woman argue a case here. You know, this was in the late 1990s. I graduated from NLS in 1997. You know, and I think, is it possible was your question? Absolutely. You know, and I will say that if my story is possible, then really anyone who loves and cares about the law and wants to work hard at it, it is a lot of work. And arguably, as first generation lawyers, we probably have to work a little harder. There's no question. But is it possible? It's absolutely possible. And I suspect that my fellow panelists in their own worlds will also feel the same way. I'm sure they've worked very, very hard. Are there impediments? Are there structural ways in which the profession is organized, which seems to prefer or give advantages to certain folks? I'm sure it clearly does, right? All professions do. But I think what is most interesting about the bar in India is that, one, you actually navigate your country's stories. And people in this country, clients in this country, are really extraordinary about who they're willing to go with in terms of representation and who they want. Clients, I think, are often miles ahead of even the legal system in terms of the lawyers that they're willing to go with. And these lawyers, like me, may not be from lineage, but will certainly be lawyers who work hard and will tell their story in court. So I think, is it possible? Absolutely. Many of my peers at the bar who are doing extremely well at the moment do come from non-lawyer families or are not related to the bench. So yeah. So
what do you think are some of those skills that make it possible? Like if you just wander into the bar, I mean, obviously you've had a brilliant education and experience and all these kind of things, but are there any soft or hard skills that, let's say, coming out of university, you feel you did not have or you wanted to have, or maybe you did have?
So I think it's two or three things. I mean, yes, it does help to have a rigorous education. But it's a conversation that Nigam and I have had in the past, that you know, you need certain core skills to succeed as a lawyer, whether it's in a firm, whether it's in a company, or whether it's at the bar as a practitioner. And that includes the ability to write well, to analyze well, to think of the worst case scenario, and I think to put forward a story in a compelling way. The part that legal education right now does not address is to teach good legal writing and to focus on analysis. And writing and analysis is closely linked, whether it's about how you reason through a complex point of law, how you write a brief, and a lot of younger colleagues at the bar will draft SLPs and draft writ petitions, and that core course, which is taught in most American law schools, and you learn in some which way or the other in the United Kingdom, that core component of legal writing, which is how you learn to reason, is not taught in Indian law schools. It is not a mandatory course, at least in any law school that I know of. And this is a shortcoming in legal education, that this is not something that is a core ingredient. I think my friend Shubha Mandal will agree that this idea of a well-written legal opinion, his own advice to the Tata Group, so much of this is about how cogently he's able to put forth his views of the law, the facts, and the reality, the systemic plateau in which the law and the facts meet each other. All of this is about being able to write that important memo well. And you write that important memo well when you can reason areas of the law. And we don't teach these two core ingredients or skill sets of any good lawyer. We don't teach them as subjects, whereas they are taught in other jurisdictions.
I think we'll definitely get back to that point. It's very pertinent. And I mean, I think the really interesting question I think that we can also consider in this is, there are some subjects that everyone agrees that ought to be studied as a lawyer in law school. where do we draw that line? Legal writing arguably is very sort of obvious candidate for something that pretty much every lawyer has to be good at, but then also moving towards soft skills and these kind of things. And I want to move from this to Rajiv Luthra, who either doesn't need an introduction or because everyone knows who he is, or we would have to spend an hour giving an introduction. But suffice it to say, he's got a very astute eye about legal education in India and what is required in legal practice. He has founded one of the biggest law firms in India, and he's very involved in the day-to-day. Now Rajiv, often it's said that, especially in law firm practice as well, it is the soft skills that are far more important than, let's say, black letter law, and that might also include legal writing. What are the sort of facets that you think are most vital to law firm practice, and also the different kind of roles that a law firm lawyer can have, right? I mean, there is management, there is transaction management, there is people management. There's so many different facets to it. Which ones do you think are sort of most vital, and is it possible to learn them all before starting?
Good morning, all. And Shova, when somebody of Menika's stature says you look just the same, what she means is you have to bloom before you wither.
No, no.
You're right. Maybe I skipped one stage.
I want to know how he's retained his youthful good looks, Mr. Luthra.
I can tell you we can talk separately over a separate
I think we should, sir.
Kian, I think currently law schools have, and their curricula has improved drastically than what it used to be, at least in my time. I'm one of the older ones on this webinar as far as the panelists are concerned. But what is lacking hugely, what people come out of law school now and get and join our firm at least, there is, I'm seeing the different generations and I'm seeing how they think differently. So let's talk just about the current, the last. So we as a firm take about 300 plus interns a year, maybe a little bit more. And I make it a point to meet each one of them, even though for a minute or 30 seconds, where I want to understand, and I've been doing this from yonks since I started the firm. They mentioned 91, but it's 90, it's not important. One of the most important things now that youngsters are looking at is, I'm not making a difference. Mm. Now that is something I don't know how you teach. When you ask them, and I've spent a lot of time with youngsters to say, okay, what do you want to do? I don't know. But I'm not making a difference. Now, if you don't know, how do I get you there? So that thinking, and now with this huge opening of the whole space and different sort of opportunities people had or have now, that needs to really be taught in school, the thinking process, the whole thinking of how you should really be looking at what you want to do. Do you really want to do law? Or is it just peer pressure? Or is it parent pressure? Like Menika, even I belong to a family of non-lawyers. My father was in the Indian Air Force, and then so I'm one of the black sheep in the family. But as we go along, I see huge, Menika mentioned writing. I think plain English, very important. Of course, Menika will tell you that as sometimes her strategy is to fill about 700 pages, so the judge admits her on Monday, and without reading it, sometimes that's a strategy too. But in real terms, if you were to really analyze, look at the opinions, and like Shua would give crisp opinions, otherwise he'd, be taken to task. Same thing with us. Long-winded opinions come, long-winded ipso factos, dehors, all kinds of wonderful words which have lost usage everywhere else in the world, but in our profession. I know doctors also have a similar problem. especially with the names of medicine, you can't even get to them. So to answer your question squarely, Kian, what is missing now when a kid comes out of school is they're not ready for the law firm environment. Why? They have no idea of stress management. They have no idea, and I think Professor Nigam mentioned time management. In fact, this is a very unfair thing you've done to us, Nigam. You brought us in after you've spoken about the wonderful research Vahura did. And most of the things that I wanted to say, you already said. But I just want to add to that. And what I want to add typically is communication, emotional intelligence, very important. And how do you manage teams? How do you communicate with your peers? How do you communicate with your boss? How do you communicate with your juniors? How do you communicate with your clients? Now, a client is happy to hear the section of the law, but not too much. The client wants to know, here's my problem, so let's go there. It's very important for a young lawyer to understand the business. Why is the genealogy? Why is the client wanting this? Where does he want to go with it? How can we get in there within the realm of law? What are the risks and how to mitigate them? Those kind of, that kind of thinking comes with time in law firms, but I wish there was a course that some schools taught. Harvard Law School, I've been talking to David Wilkins, professor, and he's very keen to start something like that and some kind of that kind of thinking. Professor Nigam alluded to driverless cars and how do you put the torts will remain and the liability will remain. But who's going to make the law? You know, there's no thinking. And in school, if we were taught how to change the way we legislate, how to change the way we think of the future. See, if you look at the past, the story was changing every 5, 7, 9, 10, 12, 15 years. Now it's changing every year. So that change we are not catching up with, even with our studies. That's the other problem.
I think some really interesting points. And I think one thing also that maybe we can get to later is what you raised right in the very beginning. How can you expect a 20, 21, 22, 23-year-old to know exactly what they want to do after having been to, let's say, school, after having studied in university and having studied theoretical law or maybe even some practical subjects? I'm sure you at that age also, with your background, you didn't know that you wanted to be a lawyer necessarily 100%, right? There's always doubt, there's always more things that you learn and you're still finding yourself. So I think it's no surprise that a lot of your interns are perhaps a little bit confused, especially with the law schools that place so much emphasis on finding a career and on being employable and all these kind of things that a lot of these kids might not have the time to think, which is perhaps also going towards the soft skills that build the other skills that you're saying would be valuable, like EQ and communication skills and other. They would kind of go in hand with that. I think we'll ask Nigam about that in a little while. First, let's go through the alphabet with Shubha, who is also one of the most influential GCs. And while he was in law firm practice also, he was one of the busiest and most sought after star M&A partners at both AZB and Shardul Amarjan. So he's got the view from sort of both sides of the coin, so to speak. Tata's itself is, with all the group companies combined, probably has more lawyers than nearly every law firm in India. And keeping that kind of structure together and strategically also steering some of the most complex transactions and regulatory issues, it raises a different sort of equation than, let's say, entirely the law firm world. I think for a long time, in-house counsel has had a reputation for just being a postbox. I think that has not been true for at least a decade or more now. And most in-house counsel are getting their hands dirty. I think what we're also seeing is that a lot of people don't start in in-house anymore. They get a little bit of law firm experience and then they go in-house, which maybe implies that in-house is actually becoming a step up. It's actually more complex, perhaps, no offense to Rajiv, of course, than law firm practices. Shubha, what do you think differentiates the sort of, you've been at Tata now for almost 3 years. what do you think differentiates the sort of skills that you need in-house from law firm, and what maybe weren't you prepared for when you started at Tata Sons?
See, I think, hi, firstly, big hi to everybody, and great to see both Professor Nigam, Menika, and Rajiv I see quite often. So great to see all of you, and of course, Kian.
We have to stop meeting like this.
That's a few months away. So I think, Kian, to kind of, first, what is different internally versus externally, if you may. That's, if I may summarize the question that way. I think the biggest thing internally is you got to learn your ability to navigate. I think it's part of what you call the soft skills, the EQ. There are people with varying skill sets. So as lawyers, we tend to still meet, externally people with certain aptitudes, right? It's easier to communicate. But when you go in internal, you're meeting people who haven't faced the law earlier or who haven't faced a particular kind of law. And so it's all the more important that communication, crisp analysis, and keeping competing business interests in mind. I think the challenge with large business houses like ours is keeping the competing business interests in mind. And let me also tell you, there's also, we have it a little bit more in Tata's, but there's also I wouldn't call it conflict, but I would say it's a competing interest of keeping, to do the right thing, whether it's with the government, with people. There are things which make better business prudence, but it may not make the right decision from society perspective or from a long-term government perspective. So drawing that balance, it takes a toll when you kind of actually lay it out. So that's a skill set. But can I say that's a skill set that comes much later in life, So I think if you want to make this relevant for students, is what Menika said. It's about the analytical skills. I think writing kind of, weaves itself into the analysis. It's the analytical skills. And I would say, two things I would say, in advisory and corporate business writing, I have a principle which a very prominent, one of the very prominent Indian promoter once told me, that if you can't write it in one page, don't give it to me. So it has to be one page, no matter what the problem in the world is. The second thing in litigation, which I think, I feel a little pained on the litigation front more than ever, because I think the whole submissions, the whole plaint writing, it's so long-winded, away from the issues. So, I still remember, I'm not a litigator, but of course I dirty my hands with it now and then. And I have this habit of putting right at the front, after I've written the whole piece, I call it the heart of the matter. I just begin the paragraph by saying, and the heart of the matter is, it's the first paragraph of the whole plaint. Because frankly, in 2 paragraphs, you should be able to summarize what are you asking for and what the facts are. I mean, the rest of it is heart of the matter, right? It's expanding. So I think the ability to, crunch everything to put it there, and that is what is missing. And I remember, we have Rahul on this call, but with Rahul, I had another session in a different forum. And one of the points I make is very strongly, and I'm convinced it's going to happen over the next decade, is India will see a massive shift from verbal advocacy to written advocacy. That's the only way the judicial system will find itself in its feet. There's nothing else to it. And it will go to the US system. I'm not saying copy the system, but I'm saying it's going to be modeled along those systems, which is crisp 20-page submissions, in-time filings, and short hearings. So what will separate are not names anymore. There could be, there could be a young 27-year-old lawyer who beats Menika because he can just put it out there better. I think for a 27-year-old to beat the generation before was not possible because it was a gated community. The community had to go through verbal advocacy, which was very defined channels. And that's changing. So, to me as a young lawyer, if I was to rewind the tape to 23, 22, this is a very exciting time. It's actually a time when I think younger lawyers can make a much bigger impact than ever before.
I think all of that rings very true, and especially the sort of speed of evolution of the Indian legal system, how rapidly things are changing, the generational shifts in the courts particularly that you can see, the even senior counsel like Minaka getting designated. I think it used to be that if you were not 65 and white-haired male, you wouldn't get a look in, right? So all these things have really shifted, and I agree, it has become a lot more accessible, partly also because of the accessibility of legal education. On this point, I want to ask Professor Nigam on what you feel the sort of role of education is, because a lot of this brings us to a more fundamental question of, are law schools there to, especially in India, to educate us for practice? Is it essentially a vocational training that we're receiving, or is it bigger than that? Is it about, and you raised some of that earlier also, but is it essentially about understanding society and understanding yourself also? I mean, it is a social science to some extent, studying law. Should we make it too much focused on employability and the skills that are needed in practice? Because a lot of those skills arguably will actually be learned during practice also. You'll have a partner, you'll have a senior counsel who you're working with, you'll have colleagues and all these kind of things. You're going to develop a lot in the first 12 months, 18 months of your career as a lawyer, things that are possibly impossible to learn in law school, right? So where do you feel that balance should sort of lie? Where should we draw that line between sort of trying to teach everything and shaping character, I guess, which maybe makes the other things more attainable?
Yeah. Thank you. Thank you very much for that question, Kian. I want to start by thanking all the participants on the panel. I had to, I didn't, when I first called each of them, I thought it'll take me a long time to convince them to come, but all of them, including Kian, very gracious to come and join me today. So thank you for that. I just can I, Kian, I'm going to come to your question eventually, but can I just start by talking? In fact, what I'm going to say now is related to your question in some ways. So, so don't worry. I see a look of alarm on your face. No, I'll definitely answer your question. But I just want to relate it to a few things that that Mr. Luthra talked about. Mr. Luthra, by the way, is famous for talking about the well-being of students. He's probably the only big law firm lawyer I know who talks about psychological well-being, and he talks about it at various forums, not just in personal conversations with me, but also at various public forums. And that's especially important in today's times, post-COVID, online learning, students are isolated. And I think that's part of it's going to become a bigger problem in the future. So of course we can talk about soft skills, but I think it's important to note, and I hope we can talk about that a little bit in the panel as well. It's important to note that the young students nowadays, and definitely going forward at least a year from now, are going to face renewed psychological pressure in their learning, and their mental well-being will become an important point of contention for all of us. So I'm thankful to Mr. Lothar for bringing that up. Now that brings me to your very interesting question, Kian. I'm going to address it, and I may have got it wrong, so please correct me if I get it wrong. I understood your question to kind of said in my presentation previously, which was the kind of these two strands of integrated legal education in India, the great experiment started by Professor Madhav Menon, which is to give a liberal-based foundation to legal education, and still try to figure out if these lawyers are more skillful at the end of their 5 years. And sometimes these two strands were considered as not coming together, but they were actually coming apart in some ways. And to address your question on that, I think the idea of a broad-based legal education, in my opinion, enhances and is complementary to the skills that, for example, Menaka and Shua have been talking about, of clarity of expression, precision, etc. I think they come together. They're complementary. And I'll give you an example from Mr. Luthra's case. So Mr. Luthra Srivastava's firm is famous for actually developing practices, not just jumping into practices, but developing it. Right? So you have, be it environmental law, environmental regulation, be it education regulation, be it securities law, LNL and other law firms, pioneers in this area. You can't be a pioneer in an area unless you have some sense of social imagination, unless you have learned some idea of what, how economics and law mesh together. It's the same case with, I think, Menaka's history as well. I mean, the kind of cases she has fought, and we're not just talking about the same-sex case we're talking about, but almost every other constitutional cases that Dr. Menaka has fought requires a sense of imagination, some idea of the ideas of the Constitution that inform practice. And you can't learn that. That's not just skill-based. That's something that comes out of a broad liberal arts education. So I think we go together. Sorry, did I get it wrong, your question, or is that?
No, I think it was spot on. I mean, I'm interested, I guess I'm digging to some extent about where you think that balance should lie. Like, should we be, because for example, in the UK or in the US, you have law school, which is specifically about employability to some extent, right? The legal practice course, for example, or the bar vocational course, or the new iterations of that. Now, should that arguably not be something that is left for the professional sphere to learn some of these things? I mean, for example, learning jurisprudence, it's probably not going to be of much relevance in any day-to-day practical job in the legal profession. But nevertheless, I think without jurisprudence, you'll never really understand why you're doing all of this, how it all fits together, right? There's certain points I feel in legal education, also in professional practice, where something just clicks. And these subjects are very hard to find sometimes, right? You can say, okay, a lawyer needs to be able to write, a lawyer needs to be able to read the law, a lawyer needs to be able to argue a matter. But then it could be a course like jurisprudence, which suddenly makes it all come together. Shubha, you have a...
I have actually, I tend to agree with Kian on this quite strongly, So let me put it, I think we should not make the mistake of moving legal education away from the core of law. The core of law is still very important. And I think what will help people in very good stead is the fundamentals and the pillars on which, what is basically the law, the very absolute basics. And when you talk something like jurisprudence, I think it's very important. It's probably more relevant today than it was ever before. So I'm slightly different when I say it is very important, the core of law. I think what the change the education institutions need to get into is to teach a very new way of thinking. I think that's what probably three of us are from the same alma mater, and that what it did to each of us individually is it made us very different in the way you approach the law, the thinking. So it's asking the why obvious, it's constantly questioning and developing it. I think that makes the big difference. So I think it would be very, and we're not very special people, the law is like most other professions, You are right, Kian, when you say there's a lot to be learned and a lot to be picked up on day to day. I don't think people should get so worried about that. But it's important people focus on the absolute basics of law. And that's one of the things that we, at least I see, is there's a slight dilution on that. People start, you may be dealing with the tech industry, but the law is still the same. There's nothing very different about the tech industry. It's still contract law at its very basics. And that's the part people need to filter, which is important.
I think that's right. Sorry,
does any... Yeah, please. I was going to hand over.
Just a minute for that. So just to respond to Shubha, yes, I think the basic concepts are still very important. Jurisprudence is still important. And some of the things I talked about in the presentation are relevant to this point, that the modern legal puzzles are still embodiments of old legal concepts. We still need to talk about responsibility and who's responsible in a contractual breach, and that will just, the application of that will change, but the core ideas will remain the same. So I agree with him on that one.
May I just jump in, Kian?
Yeah, absolutely, please.
Since I'm not from the school and I'm not restricted with knowledge, basics of law is very important, I agree. But I think we have to go a little behind. We need to teach the genealogy of why this law, why is this section being brought in, what is the reason. That'll do two things. One is that'll make the student much more interested in learning the law instead of mugging it. Second, when you apply it, your understanding is much better. And there have been, there are many, many laws which are flawed, as we know. And once you read the parliamentary speeches, in fact, in my library, in my office, I have every single parliamentary speech where a law was or a bill was being debated. And my librarian came to me and said, "Sir, ye to bahut, this is very old now, we can throw it out." I said, "Don't you dare. I have every single budget speech right from 61 onwards in my office, because that tells you why that law was made. Why do we have such a complicated income tax act? We have a section 80, which started as one single section. Now we have section 80A, 80B, 80BA, 80BBA, till 80VVA. That's how the whole story has been complicated. And if lawyers don't understand that, you're not going to get very far.
No.
What?
Sorry, the school, I had to add to that, since
Yeah,
I'm not restricted.
No, clearly, Mr. Luthra didn't need much of the education that, the rest of us had to. We just took longer to learn the same basic legal concepts in this little law school tucked away on the edge of Bangalore. But I completely agree with him. The genealogy of it, why this law. And maybe I want to also extend it, because I suspect that we'd all on this panel agree. The law is a wonderfully cerebral subject, as a discipline. It is this lovely intellectual way of life where you are constantly reading, whether it's Mr. Luthra going through parliamentary debates, whether it's Shiva, I suspect, reading about the origin of many of the businesses that he runs, whether it's the founding of India's constitution or who founded it. It's interesting that there were so many lawyers involved. But at the heart of it, it's a reading, writing, thinking job, and the why, where does it come from, is very integral to it, right? But what it also provides each of us, right? It provides each of us an opportunity to really live an interesting life. That is the most wonderful thing about being a lawyer, whether it's at a large company, whether it's at a large firm, whether it's teaching in a classroom, whether it's arguing a case in court. It teaches you to imagine the world that you live in. It teaches you to let that world in. It gives you the opportunity to meet people whose stories you will tell, whose life facts you will analyze. And that is what it provides. And somewhere in that, legal education and perhaps our workspaces have to bring that element to students' lives, interns' lives, young lawyers who go to the bar, young lawyers who join firms and companies, that here is a way where you can actually have an interesting life. And the law is interesting because it tells you of our origins and it tells you where we'd like to go. So sort of locating it in that journey, I think, is very important. And this is where, law schools play a key role, because you start that journey. You start that process of imagination.
I think, Nigam, as an educator, this is a very tall order that you've got from your panel here to teach students how to make their lives and others' lives more interesting, right? What do you think are some practical approaches to that in education, right? I mean, there's a lot of different theories and approaches. Some of them might be called the sort of GLC Mumbai model of just throw them into internships and they will learn on the job, which is inarguably effective, and it yields very good practical sort of skills even before graduation. What can be done in a classroom to do some of these things, in your view? And particularly on the interestingness, particularly on seeing the bigger picture of society, how do you think that can be done?
I think making them think on their own and asking them to try out and experiment with new approaches, I think makes a huge difference. So I'll give you an example that I give often about my own experience at the law school. Mr. Luthra might say I'm talking about the law school again, but if he can indulge me for a second. So when I went in my first 2 weeks of law school, we had contract law in our first trimester. I had to do a project on Section 56 of the Indian Contract Act, which is impossibility of performance. You know, for a person who's come from high school and has got into the first 2 weeks of law school to do something on Section 56 when he doesn't know the first 55 sections of the Contract Act, is quite a tall order. Right? And I often wondered, well, what was the point of that? What was the point of making me do something on a subject that I had little knowledge of? And actually, it turns out that it was one of the most interesting things I did. I mean, I had to learn everything from scratch within a limited period of time. And I didn't learn it because an instructor told me what to say about 56, because there was no instruction at that point of time. We were still in the first 2 sections of the Contract Act. So I had to learn it on my own. And I think that was the point of that project. The point of that project was to say, you do an independent study. There will be some mentoring. What we want you to do is, as Menaka might put it, lead an interesting life. Maybe I didn't look at it that way at that point of time, but it was an interesting 4 weeks for me, where you try to engage with the law on your own from your perspectives. And that's something that I'm trying to do it has to be done properly though, Kian. So it can't be that you do a proper project on Section 56 and then the instructor looks at it for 2 minutes and gives a mark which is nowhere related to what you've done. So that it won't work that way, right? So there has to be a proper feedback mechanism and the instructor has to be actually interested in what you're doing. But provided those supporting mechanisms are there, we can make law interesting in the classroom in the way.
I think it's really interesting. I think it also raises another point, which maybe we won't have time to get into today, but delivering that kind of education, which is inspiring, say, and makes you lead an interesting life or helps on that road, it requires teachers also who are leading interesting lives and who have experience and who have passion for the subject and these kind of things. And traditionally, I think law schools have, including law school with a capital L, has not provided necessarily the incentive for these professionals, some of them also in legal practice, to say, I want to give back and teach, for instance. And it's not just giving back, it's also the fulfillment that you get in your own right. Even that was not really there because lesson plans were very fixed and the ideas weren't necessarily there to allow teachers to give these kind of experiences to their students, right, to have that freedom. But like I said, that's a much bigger nutshell that we don't want to get into. What I was wondering if some of the practicing lawyers that we have on the panel had any thoughts on some of these soft skills. For example, Shubha, Tata's is infamously a very political company as well, but it's also got a very strong corporate culture, right? Is it possible to ever train someone to learn how to do that before jumping in feet first? Like it's sort of a trial by fire in many ways, landing in a corporate or even a law firm, any organization for that matter. Are there any tips that you have or any academic ideas that could help?
So I don't think, too much can be taught, you know what I mean, on these aspects. It is part of life's experience, the experiences keep changing. What you face when you're 28 is very different than what you face when you're 40 or when you're 50. So this is going to be a journey. So I wouldn't, want to prescribe too much in this. Each people, it depends, growing up in Delhi, working in Delhi has a very different experience from somebody doing that in Bangalore or Bombay. So there are a lot of nuances to this. So, I think one thing which I would say is going to help, and again, a lot of things I'm saying is I see things happening over the next decade. It's not about 2020 as much as what's going to be the end product in 2030 or which way the world is going. I think globally, there's a big trend that is changing in the legal education space, and I hope India picks up. I hope Professor Nigam picks that up sooner rather than later. I think lawyers have become, that by training, I'm focused on the training only. The training is, as Nigam used that word, teaching them how to think or learn. It's become very uni-skilled. So it's only about the law. And that needs to change, where I think you need to have a little bit more multidisciplinary approach. So if you start talking to the magic circle or the US top firms right now. So I was speaking to a few folks in Kirkland today, 2 weeks ago, and it's almost 20% of their fresh recruits are lawyers who law is a second degree. So they could be a biotechnology person, they could be a computer person, they could know coding, they could be a mechanical engineer. So law is the second degree. And I'm not saying India needs to make law the second degree. That may be a bit more radical, but definitely take somebody like me, at least I can speak for myself. You know, I would be poorly trained in today's world because, you know, the basic core of the learning is on the law alone, right? Everything else is acquired. I think that needs to change. Where somebody needs to adopt. He could be a marketing person. He could just know what's branding, but they should learn that in college, which is a little away from the law. So there should be a few more, I wouldn't call it to the extent of second degrees, but definitely has to be some core skills which have to be seriously taught. It's a little beyond the law right now. And that's what in 2028, that's how the hiring will take place. You can't just flash a legal degree and say, I'm a good lawyer, so hire me. That's not going to happen.
And if I may kind of jump
absolutely.
in just for
of course.
a minute, because I completely agree with Shiva. I mean, I think the difference between, you know, and I've taught in India and I've taught in the US, and the difference between my Indian students and my US students is exactly this, that the average American JD student has a first degree in whatever subject, be it physics, chemistry, history, and is likely to have even worked a year or two or more before she comes into law school. So by the time she's doing this first law degree, Kian, I mean, she has had an entire mini lifetime seeped in another discipline that she now brings to the law. And the law will now complement this discipline. And so as lawyers, you bring in really 2 or 3 methodological skill sets to your work, to your craft, right? So I think that's extremely important. And the second thing which is happening simultaneously, and therefore, you know, this is building on Shiva's point, is that certainly in America, I mean, there is the advent of AI. And AI is being used by law firms. And I suspect it's being used here as well. And that means that suddenly the first, second, third year, and maybe even fourth year associate is looking at his or her positions contracting. Because there is AI doing a lot of document review. There is AI doing a lot of simple first, second, third year tasks, which also makes it infinitely more affordable to the firm and to the client. This is the other thing that's happening.
Absolutely right.
Of, you know, clients of major law firms. I mean, my first job in the US, I worked at Davis Polk Wardwell, a big American law firm. And a lot of what I did as a first year was document review, maybe on big transactions, but it's document review. Much of what I did today can be done by a software, and probably with fewer mistakes at a fraction of the cost that a first or second year associate would bill out.
Yeah, I'll take that. Sorry, I want to expand that a little bit more. I think that's the first layer. That's what Menika said. I could not agree more.
Yeah.
Then there's a second layer that's building. So if you take, you know, I'll just bring myself in. If you take someone like me, the way I started off in 22, 23, and the skill sets I've acquired, I think if somebody did that, they would be far less redundant, far more redundant going forward.
Absolutely.
And why is that the case? Because it is these same technologies that Menika is talking about. It's going to make capital markets, insurance laws, corporate laws less, I wouldn't use the word relevant, but less valued. You know what I mean? What was valuable in 2008 when you gave that very strategic corporate advice comes out very easily in 2022. So you're going to be less valued in the value chain. On the same hand, these technologies will make certain career paths regulatory, the entire interface between public law and business law, the whole litigation, the whole litigation space, again, some kinds of litigation, not every kind of litigation. Areas around commercial negotiations going to be much more interesting. And these will be the value propositions going forward. So since we have a huge student audience, it's important people realize that you're standing in a position that what people did in 2008, if you photocopied that and did that today, you've got another 30 years to be in this profession. It's disaster.
Yeah.
I think it's really fascinating. I want to pull back a little bit from the technology side because that's the next panel also will be delving a little bit deeper into that. Although I'd love to go into this for another hour with this great panel that we've got. Coming back to the sort of education side of it as well, Rajiv particularly, for example, law firms spend a lot on training, right, when someone joins. And that's also in, let's say, the US and UK firms as well. They have very advanced training programs, and they just spend a lot of money on every new associate that they take in. The same is true in Indian firms, even if there's at the smaller ones not such organized training programs, perhaps, just in terms of partner time and the sort of mistakes that have to be fixed and other things. It is expensive taking someone on, right? Rajiv, how much of this could you see being taken over to some extent by LLB programs, either the 5-year ones or perhaps even sort of programs in between that? Is it something that a law firm would want to be done outside of its own four walls? Because every law firm also has its own standards of quality and the way things are done, its own documentation. Like, would this be something that's useful if a law school product came to you and said, yeah, I've read 10 SPAs and I know my way around a contract?
So, Kian, interesting you say that. This is a very, this area is very, very close to my heart. And regularly we try and hold training sessions, etc., particularly in the last 120 days. With this whole shutdown, work from home, and this wonderful Zoom and Teams, etc., we probably, if I'm not wrong, we've done about 18 or 19 training sessions. Now, I'll tell you why that is important. So let's say today, one of the basic fundamental problems is it's become an age of specialization. There's a lot of peer pressure. Hey, M&A is the new game in town, or capital markets is the new game in town, and that's what people try to specialize in. I think that's a fatal flaw, because if I'm an M&A lawyer and I don't know what Professor Nigam teaches so well, and especially Section 56 he talked about, now he's the czar of force majeure in India. So, I mean, these fundamental things that we don't try to generalize. In England, they do this. They transfer you to one division to the other. Because at least when you're negotiating, for example, negotiating a power purchase agreement, you can raise some red flags. You may not be an expert at it. So what happens today in most law firms, if I'm an M&A lawyer and there's a tax issue, I send it to the tax partner.
Right.
I don't analyze it. I don't try to so I keep insisting that no, we won't bill the client, but you analyze it, come up with the answer, then go to the specialist. So two things can happen. The specialist partner can give you 2 tight slaps depending on how they communicate, and say, what rubbish is this? Or say, this is excellent. Both ways you've learned. So that is an extremely important thing, that we should change this whole specialization nonsense. First be generalists and then specialize. It's very, very important, and that is what law school should teach. So what law school does is gives you silos: securities law, contract act, all of those silos you are taught. But some of these acts, 3 of them or 4 of them become M&A. 2, 3 of them become capital markets. 4, 5 of them become project finance. If they were to teach those as well as finishing school, it would make a big difference, especially, and save a lot of cost to law firms.
Yeah, I think it's it's definitely an interesting challenge, because especially in this kind of climate, law schools are going to be facing this increasingly, that recruitment is probably going to be affected from law schools, from corporates, and the graduates that arguably have that, let's say, project finance training might have a sort of easier way of getting into a project finance firm or any corporate firm, right? So it's a tough question, while at the same time maintaining that holistic view that you also described, stopping it from being siloed, and learning the theory, actually pulling it all together. I think that's the sort of the magic sauce that makes a legal education more than just an accumulation of case law and case studies and problems and sort of historical knowledge. And I think that's sort of very, very hard to pull off for any law teacher. And I think we're coming towards the end of our allotted time. I wanted to get a little bit of audience questions in as well. One of them, in fact, was it, which I think you've just addressed, Rajiv, is saying which area of law would be most useful to specialize in with technology and all these things coming on. So I think you've kind of gone into this. One question is, and perhaps anyone can take that, and who feels interested. How do you suggest that we improve our reasoning skills? Someone has asked on the Q&A. Is there some practical advice that one of the panelists would like to give on this?
I'll just quickly jump in. I don't have too much to say on this. I think it's practice. I think it's the question of making sure that they think deeply on any subject that is taught. And I just want to clarify one thing. I want to take off what Mr. Luthra said. When he said holistic knowledge, I'm sure he didn't mean the end product, but he meant the process. So he meant that have the ability to think holistically, and of course the end product of that holistic analysis differs and changes from time to time according to business needs. But the ability or the kind of attitude of synthesizing things together is not taught in law schools at all, right? So we jump from contract to then property law and then to constitutional law, but we never are given an opportunity in our assessments or in any other way, even in our projects, to actually bring these different strands together. And I think that ability, that attitude is important as a process, is I think important.
So just to take it further from Professor Nigam, if I look at reasoning, was I think Kian's question. Let me go back to my earlier comment. Let's look at genealogy. If we start there, your reasoning starts to get more. I don't only mean genealogy of law. I mean genealogy of the question of your client. If your client asks you a question, if you try and understand why is he asking this question, where does he want to go with this? If you can understand the basics of that and where it comes from, your reasoning starts to improve very drastically.
That part of, and I completely agree with Mr. Luthra, with Nigam. And I think part of this is also, what is the kind of advice you provide? And I'm sure that part of what Mr. Luthra and Shiva do, as I do, is we also recognize the social landscape. We recognize the political landscape, the economic landscape, the markets as they're placed before you give complete advice. So much of legal advice is not just what is the interpretation of Section 56 of X statute. It is also what is the social, economic, political, and legal landscape in which that statute is located. What is it likely to result in? Is it actually an effective way of remedying the situation? So I think this is where this kind of holistic education comes into play. It enables you to see 360 dimension. And not just interpretation of a statute.
Moderator, I want to make a complaint.
Please, anytime.
Monica is discriminating. She's calling him Nigam and me Mr. Luthra. Either call me Rajiv, Luthra is fine, but why Nigam and me Mr.? That's discrimination.
I think at this point it needs to be said you're also looking very youthful and good today, Rajiv.
I agree.
I think we have 4 minutes left. Please, Nigam, stop me if we're running over. But I think that's a very interesting point that both of you raised just now. And I mean, from personal experience, when applying to work for law firms, what was most important was actually understanding the business world, right? If you want to be a law firm lawyer and you don't understand how business works, it will be incredibly difficult going the first couple of years because you're going to be picking all of these skills up. And law schools don't really teach business, and I don't know if that is something that they will get into. So the most useful thing maybe that students need to do is, and that law school can maybe not provide, is that they need to take an interest themselves and read, let's say, Economic Times and Mint and newspapers while they're in law school to try and get their head around the vernacular that their clients are going to be using. And that's probably going to give them a really big leg up. I don't know if that's something that law schools want to teach or encourage, or if it just happens automatically.
I think
Nigam, you can have a...
I think there's a lot of, I mean, I don't mean it in a bad way, but I think that's really not, Kian, I tend to slightly differ in the way you approach the issue in the sense, look, I think what Menika said is very important. As a lawyer, it doesn't matter. It's not about the business work. It's a very small part of the legal work. So I think for young students aspiring to be lawyers, even you could be a public lawyer and you're faced with taxation issues. You're faced with data privacy issues. And you could be faced on a constitutional issue on a particular law. Now, it is very important to understand the underlying subject matter. It's not just about the business community, right? The business community, I think this is one big, I see a big issue in the legal community is it tends to get very focused on the business part of it. And we say it's the law firm, but it's actually more true for a litigating lawyer to understand the economic issues or the business issues. Way more important. It's probably because the person out there has to write it and advocate it. There's a reason why it's called an advocate, right? It's advocacy. So it's absolutely, he has to be wearing the shoes, wearing the clothes of the client to be really advocating that. So I think it's true, generally speaking, for the whole legal profession. It's not linked only to the business world or the law firm world.
I want to add to that, Kian. See, Shova is one of those... Very quickly, Shova is one of those great guys who has fixed clients. But if I know a business vernacular, I know the jargon, it's easy for me to enter in the door. Once I'm in the door, what Shova is saying is right. But till then, there's always a challenge.
Unfortunately, and I think everyone feels like there's a lot more to say in this topic, but unfortunately we'll have to wrap up, I believe, due to time.
Sure.
But I think it's been really interesting discussions and a lot of great food for thought as well in legal education. Nigam, do you want to have a short final closing argument, so to speak?
No, I think it was a great discussion, and I wish we could talk about it for some more time, but we are unfortunately running out of time. But I thank all the participants for a wonderful and energetic discussion on this subject.
Thank you so much.
Thank you.
Thank you.
Thank you.
Thank you, everybody.
God bless.
Thank you.
Thank you, Kian, for
Absolute pleasure.
wonderful moderation.
Thank you. Bye.
Thank you.
Thank you, panelists. Thank you, Kian, for moderating this session. It was an extremely enriching and, as Professor Nigam said, extremely energetic discussion. Thank you for emphasizing that for students to excel in the law field, the law school perhaps need to have some soft skills on the curriculum and need to transition towards vocational teaching style. A style I can say that we practice at School of Law, BML Munjal University, by making learning experiential. Thank you once again. Now, it's time for the second panel discussion for today called AI, Tech and Legal Profession. The COVID-19 pandemic has forced most professional services, including the legal services, to be shifted onto virtual platforms. The legal profession is now coming to terms with the changing ways of interacting with clients. Thus, for lawyers, knowledge about technology has become indispensable for varying reasons, ranging from bringing efficiency in service delivery or understanding the needs of the client, given the increased load of technology in how businesses work, or perhaps due to changing ways of functioning of law firms and courts because of introduction of law-specific technology. Keeping this in mind, this panel will discuss the role of technology in the contemporary practice of law and the scope for its use in the foreseeable future and its inevitable disruption in the practice of law. May I now have the privilege of introducing our esteemed panelists for this session. In alphabetical order, we have with us our first panelist, Ms. Jagrati Bhattacharya, who in her role as the Chief Counsel for Refinitiv has legal oversight of the sales organization as well as of Indian enterprise technology and operation centers. Prior to this, Ms. Bhattacharya was Chief Counsel for Thomson Reuters, heading the legal function for all business units and operation centers SPP South Asia. Ms. Bhattacharya sits on boards of directors and provides corporate governance advice. She is a keen supporter of CSR and DII initiatives and has chaired chapters of Women's Network in her organization. Our second panelist is Mr. Rahul Mathan, who is technology lawyer and a partner with Trilegal. In addition to advising clients on diverse issues such as cryptocurrency, satellite regulations, fintech, and social media, he has played an active role in the tech policy of the country. His book, Privacy 3.0, Unlocking Our Data-Driven Future, provides a good look into the evolving and changing relationship humans have had with privacy. Rahul has an abiding interest in the intersections between law, society, and technology, a passion that finds expression in his weekly column in the Mint called Ex Machina. A third panelist is Mr. Sandeep Kapoor, who is the founder and managing partner of Algo Legal and comes with over 20 years of experience in investment laws, M&A, capital markets, and technology law. As an early adopter of technology, he made significant contributions to transformation of an in-house practice of the legal function in India. Prior to Algo Legal, Sandeep spent 9 years at Secure Capital and left Secure in 2019 as Director, Legal for Southeast Asia. Sandeep has been featured in Legal 500's GC Power List India and has been the recipient of the Best In-House Legal Team at the Financial Times Legal Awards 2018. Our fourth panelist is Mr. Ritvik Lokus, COE and founder Vahura Legal Talent Management Limited, who I have had the privilege to introduce before. This session is being moderated by Mr. Nikhil Kanikal. Nikhil is an interdisciplinary professional who has spent a decade working at the cutting edge of storytelling, business strategy, and technology. Nikhil began his career with the Mint, one of India's leading business dailies, as a staff writer covering law and the courts. He graduated from Columbia University as a Tony Stabile Investigative Journalism Fellow. He is a visiting faculty member in the Asian College of Journalism. I welcome all the panelists and the moderator. Over to you, Nikhil.
Thank you, Dr. Chavla. It's a pleasure to be here. And at the very outset, I'd like to thank everyone who's made this possible, in particular the BML Munjal University, as well as Vahura. And thank you for inviting me, as well as this absolutely fantastic panel. So I'm just going to start with introducing the topic that we're going to discuss today. And as you could tell by listening to the panel before us, it's clearly a very interesting and eagerly debated subject, because even though they were talking about education, it inevitably led to a discussion on technology and the legal profession. So the topic is, as has been set out, it's artificial intelligence, technology, and the legal profession. And I just want to make a small deviation here and tell you about a couple of personal experiences through my journey and how I've seen technology and the law intersect. As Rahul Matan, one of the panelists here, had said to me just a day or two ago, this is one of the industries yet to be majorly disrupted. It's one of the last industries that's sort of still stuck in time. And Ritvik had mentioned this earlier during his presentation as well. So I'm taken back to a time about a decade ago when I first heard in the Supreme Court arguments to live cast or video cast the proceedings, just like is done in other jurisdictions. And what was sort of funny or remarkable about this was that the fact that this was actively being litigated as a dispute before a bench, before the highest court of the country. So in our conceptualization of how technology ought to intersect with law and sort of how archaic some parts of the profession have remained, this was a small sort of funny anecdote. The second one is more recent, when I had the chance to visit Lucknow, and passing by on the left, I saw this massive stone complex, which I then read on the board was the Allahabad High Court bench in Lucknow, it sprawled on for eternity, it seemed like, and felt like more of a presidential palace than a courthouse complex. And this was a newly constructed building, this massive edifice. And again, seemed a bit odd and funny because in today's times where we have, so many professions changing and being disrupted, and when you think of industry and disruption, the word that's not in our topic today is disruption, but inevitably when you put it all together, that's what we're really talking about, disruption of the legal industry and the legal profession. To my mind, there are names like Travis Kalanick and Uber and things like that, because these are some of the most, this has been one of the most disruptive companies to have gone around the planet and changed societies in the recent past. So when is the legal profession sort of going to see something like this? Is it on the horizon? Is it, is it already here and we don't know it? So what we've got today is a really interesting panel. I know they've already been introduced, but what I'm going to do is just explain how we're all sort of putting this together, which is, and we're going to start first with Rahul, because Rahul, besides being the founding partner at Trilegal, is also a thinker about technology. He has a deep passion for technology. So he's going to perhaps explain to us where he sees this going and make a few predictions as one of the legal, leading practicing professionals there today.
So I could only
go to Jagrati, who in my view is perhaps in the best possible place to be as a legal professional today, because she is she's the general counsel at the cutting edge company when it comes to the tools in the legal profession. So she possibly has access to the best stack in terms of legal tools, perhaps some of the best talent in the profession. So how does it, from her point of view, look like when it comes to technology in a corporate setting? Then we're going to go to Sandeep Kapoor, who until very recently was a transaction lawyer in-house as well. But what's more exciting in my conversation with him was the fact that he is currently building some of these tools himself. Sandeep, again, is a visionary. He seems to be a pioneer in the space. He's putting together teams of interdisciplinary professionals, engineers, design process managers, and so on and so forth. You'll hear more about that when he talks. And finally, but absolutely consequentially, we're going to come to Ritvik, who for the last decade has had a very interesting point of view because of what he does, what his company Vahura does. So Ritvik has possibly the sharpest, keenest eye in terms of where legal talent is going in India, how it's shaping up, where there's the maximum sort of demand, and where is the demand and supply equation with legal talent. Perhaps, he's in touch with most of the law schools, so he knows the quality of talent coming into the market. So Ritvik's going to give us the broad trends, and perhaps wearing his Agami hat is also, like you talked about earlier, he's going to talk about online dispute resolution as well. So that's my little spiel. And before I get any further, let's open this up. So Rahul, welcome you to please share your introductory remarks and then get deeper into it.
Thank you, Nikhil, and thank you, to the BML Munjal University for inviting me. It's great to be here. It's great to see, to be at the beginning of a new university, and to find it so well populated by fellow colleagues of an old university that I was part of. I was listening to some of the remarks in the earlier panel, and even in Ritvik's presentation earlier, and I have, I guess, a few comments on that. But just in terms of maybe even Nikhil, your introduction to say that we're the last to be disrupted, and that's true. We're sort of the last industry left standing. One of the biggest reasons why people disrupt existing institutions is because there's too much friction, and all of disruption, if you think about it, is really easing friction. And so just take the Uber example that you gave. We are looking to ease the friction of traveling from one place to the other, and Uber came up with a great example. And one of the reasons why law is not is so difficult to disrupt is that lawyers, judges, and to some extent even law schools are involved in creating and perpetrating the continued existence of friction. We do that by using arcane legal language, language that is very difficult for people to understand. When we go to court, we have arcane procedures and processes that unless you're a lawyer, you have no ability to deal with. And so, we're a very, very disruption-proof industry, and not to in any way belittle the impact of the legislators who are largely lawyers and who seem to be committed to keeping it hard to disrupt by refusing to allow competition from international law firms, competition from chartered accountants and things like that. This is not to say that we should do any of those things, but just to give you a sense of why it's so difficult to disrupt. But having said all of that, the World Economic Forum came out with a report some time back, maybe 3 or 4 years back, where they went through the list of jobs that were most likely to be replaced by robots. And I was very gratified to see that lawyers were the least likely to be replaced by robots, beaten only by nurses. And so it gave me a sense of relief. But when I read down that list, the job that was probably had a 94% chance of being replaced by robots was the first-year lawyer and the paralegal. So what the report was actually saying is that the highly skilled lawyer has a very low risk of being replaced. But the first-year lawyer, the paralegal, the person who in many ways has just come out of law school, is at dire threat of being replaced. And I know I'm saying this to a bunch of students, and you probably want to kick me off this panel immediately because this is not very encouraging to someone who is just about to start a career in law. But that is the fact. In our practice of law, we're seeing this happen, not at the top, but we're seeing it happen at the bottom. Companies like Jagatis that actually build this technology have now technologies that automate a number of things in the practice of law. You have document creation, which is now, you can be largely automated. You have due diligences, which can be now significantly assisted with artificial intelligence. You've got legal research, which is actually becoming easier and easier to do thanks to some of the things that Professor Nigam said was not around when he was in law school, and certainly was not around when I was in law school. And all of these things are making it making that first-year lawyer in a law firm more and more redundant. In litigation, once again, a lot of similar challenges. I mean, I was at a similar panel where Justice Chandrachud, who is in charge of the e-courts initiative, came up with a rather radical statement. He said a lot of our disputes can be solved algorithmically. And if you think about an insurance dispute, a good portion of that dispute has an algorithmic solution because essentially it's logical. And then, so those are the sorts of disputes that may come up before Justice Chandrachud. But if you think of the large volume of disputes really at the lowest end of the pyramid, take traffic offenses. There's a program, an artificial intelligence program in San Francisco that would pick up traffic offenses. Mostly you'd go and pay your traffic offense, but they said, look, give it to us and we will win it. We'll give you a chance of winning it. And they just ran an AI algorithm that had gone through all the procedures, and they found that by and large, the police make some procedural irregularity, which would result in the traffic challan being actually thrown out. And they had a success rate of something like 30 to 40%. And that's just an artificial intelligence algorithm against the police system. So if we think that litigation is not going to be disrupted, in all circumstances, you must look at the bottom of the pyramid, because disruption comes where you least expect it. So what does this mean in many ways for this audience that we're talking to? What does this mean to the law firms on the panel? What does this mean to the law school? What does this mean for law students? Well, I think we've got to have a slightly different approach to the way we think about legal education. And I say that as a partner in a law firm because the way we think about legal education has a direct impact on our intake of lawyers from law school. I think much of the practice of the law has been dependent on what I wrote an article maybe a couple of years back, which is entitled "The Death of the Artisanal Lawyer," because law, even in 2020, is an artisanal profession. You learn on the job, very much like if you're a leather maker in the medieval age, the only way you could learn it is apprentice yourself with someone who taught you. And so the first 2 years of legal practice, certainly in my firm, is learn on the job. And it takes 2 years of learning on the job to make someone equipped to become a producing fee earner. Now, those 2 years are going to be lost to artificial intelligence. And neither the law schools nor the law firms are equipped to deal with that. Our clients are going to insist that we do not use first-year associates. We're going to have to pay for the first-year associates because we've got no other way to make a graduate from a law school into a third-year associate. And there is no job for a first and second-year associate. So what do people who are graduating out of law school, what should they be doing and what should law schools be teaching? This is perhaps a radical statement to make, and Nigam, I'm sorry if you've already got your course material, but you may have to change it. What we really need is we need people who actually know how to use these technologies, because in maybe 3 or 4 years, if you don't know how to use these technologies, you won't have a role. And what do I mean by that? Artificial intelligence is not perfect right now. You still need to be able to translate the output of artificial intelligence as it can be used by a litigator or by a senior lawyer. You need someone to help with that process. Unfortunately, it's getting much, much better. Just a couple of weeks back, the OpenAI Institute released something called GTP3, which is such an advanced piece of artificial intelligence that they announced it by writing an article. And at the end of the article, they said the entire article was just written by AI and you didn't know that the article about AI was written by AI. That's the kind of competition the first and second year lawyers are going to start facing. And if we don't gear up for that, we are going to be disrupted. I can expand on some of these, but I do want to give the others a little chance to either contradict my radical statement or support it. And I look forward to the rest of the panel.
Thanks. Thanks so much, Rahul. Very insightful opening remarks and broad strokes that you've painted. And I'm sure we'll get deeper into each of those with the experience of both Jagriti and Sandeep, who are perhaps deeply embedded with some of these. So let's quickly move to our second panelist, Jagriti Bhattacharya. Jagriti occupies the position of General Counsel at Refinitiv. And as we've said, she perhaps has one of the best possible legal toolboxes in terms of technology at her fingertips by virtue of the fact that she works with one of the leading companies that build these tools. So Jagriti, if you could also explain to us from the perspective of running a global legal department across many jurisdictions, please share your thoughts.
Thank you so much. It's a pleasure to be here. Just one clarification. I used to work for Thomson Reuters, which produces these fantastic legal tools. And I work for Refinitiv now, which produces, again, fantastic tools for the financial and risk community. But my perspective here emanates out of, again, being part of a global legal department. And the need for a global legal department is for technology that can serve the needs of a varied group of individuals that make up the department. And a solution that looks to seamlessly put together the priorities and the long-term growth strategy of the department. So while we're a cost center, we operate as a vertical with similar goals and priorities that other businesses have. And historically, departments developed a system in-house to manage documentation, to manage knowledge sharing, to do administrative things like invoicing. But that isn't the core competency of a legal department. And over the last 20 years, we saw a shift to adoption of readily available technology that a legal department can use so that it frees up the times of the lawyer to focus on the core high value, high priority work. So the entire move to technology is not about eliminating jobs. It's about increasing efficiencies. It's about reducing cost. And it's about ensuring that our lawyers and our team of lawyers continue to enhance their knowledge by doing much more higher value, complex work that adds to their experience. The department itself needs overall a seamless, secure tool, functionalities, technology that connects geographies, that is cost effective, that has multiple functionalities at one touch point, or that is able to marry different efficiencies and functionalities at one touch point. And again, different sectors have different requirements. So your pharma companies will have specific regulatory needs. Your insurance companies will have different regulatory needs. Banks obviously have a host of reporting requirements. And it's the unification of all of these tools and functionalities across different service providers, across different needs of different people within the legal department that then brings us to where we are with wanting different forms of technology for lawyers.
So Jagrati, if you could also expand a little bit about the unification of tools. What does that really mean for somebody in law school, looking at,
Sure. So, we need to look at what our in-house counsel's role is. And again, a very important shift in the last 20 years, for example, is we've gone from being perceived as a post box who's giving work to outside counsel to being the lawyers who people are relying on. So I'll give you an example. When I started out 20 years ago, derivatives was an unknown terminology in the legal sphere. I didn't know anything about derivatives. I wasn't taught anything about derivatives in law school. But I joined ICICI Limited. I learned hands-on. And through that learning, we also it was a symbiotic relationship with another law firm, which then became the #1 law firm, which was advising on derivative transactions, because they learned from our transactions. So similarly, for any legal department, our first role is client delivery. We get requests from clients, whether it's legal opinions, whether it's contracting, a host of different things. And the first important technology requirement for us, and which we're seeing moving from being a manual process into being a technology-driven process, is to streamline these delivery requests, right? So when I get a request for, say, a non-disclosure agreement or a name change of a company, this is very, very low value work for a lawyer. It's a no-brainer. Our lawyers shouldn't have to spend any time or effort responding to these things. So you set up this seamless way where standardized requests can be responded to, or there's a mechanism where the business can do it themselves. So that's the first level of technology that has been useful to legal departments across the world. Earlier, it used to be driven by a manual process. You set up a mailbox, the request came in, somebody picked it up, responded to it, etc. But it can be automated today. And what does this do again? It reduces time that lawyers are spending on low value work. The second piece of very, very important technology tool that we are using now is contract management. So from creation to review to approval, execution, everything can happen seamlessly. We've, especially in the COVID era, while again, not all companies have adopted these technologies, but where we're working in a virtual office environment, a tool, a technology enabler that can make all of this happen without the physical presence of lawyers or the physical input of lawyers is absolutely critical and valuable. And then the tools these days are able to also extract key terms from these contracts, put it into a database for future reference. So you have data and analytics at your fingertips, which is then AI driven. The third important piece is document management. So we're generating thousands and thousands of different forms and variations of documentations globally. And historically, there was never a single touch point place where you could click and get any of this data easily. But very important now is secure database, where you can store data, access it, and share it. at the touch of a finger. So these are some of the core ones, but over and above this, there is virtual data rooms, there's compliance and reporting. A key piece is legal operations. Every big company now has a legal operations manager, and their role is critical to functioning of legal department, where globally it's runs into 200, 300, 500 people. Project management, whether it's an M&A transaction, whether it's a divestiture, whether it's restructuring or different legal entities being merged into one, whatever be it. Project management tools for lawyers, and where the lawyers are interacting with outside counsel, they're interacting with vendors, there are multiple stakeholders, there's documentation, there's data, there's coordination across geographies, there's status report, resources, everything is getting collated through these tools. The last thing I'm going to talk about is to look at the requirements of technology from the perspective of different individuals within an organization. So your general counsel needs a lot of data, needs data to be able to fulfill audit requirements, to be able to report to the board of directors, to be able to comply with regulatory requirements. And whether it's litigation spend, litigation status, compliance data, outside counsel spends, for the general counsel, that's what he needs. For him, that's what's critical. For your legal operations manager, who actually is the one point of contact and who manages the entire global legal team, he needs a lot of data and analytics, and is also responsible for creating dashboards, for managing expense reporting, and is also the one who's going to advise the general counsel on how to optimize resources, how to increase efficiency, and how to better manage the legal department as a whole. But compare that to your 3-year PQE lawyer. The 3-year PQE lawyer needs something very, very basic. The person might just need guidance on whether a certain intellectual property sort of agreement has ever been drafted in any other part of the world. So instead of duplicating efforts, that lawyer should be able to search through a database, look for a contract that serves his purpose, or look for a framework that serves his purpose, and be able to then build on that, which is again different from an M&A lawyer's requirement. So when we look at technology, I think there is looking at it holistically, strategically, from what you want your legal department to be in the future. What is your long-term growth strategy? What are your priorities? There's that piece. There is the piece of the different pieces of work we do, the functionalities we need, which then needs to marry with the needs of the individuals within the legal department. And last but not the least, it needs to fit into the ecosystem of in-house counsel, our in-house clients, and the outside counsels who work with us. So for me, this is how I approach the technology shift. And we're seeing tools, we're seeing functionalities that are serving all of these purposes.
Great, thanks, Jagati. We'll circle back to you in a short while for the conversation to understand a little bit more about the strategy for growth for the legal department within an organization and things like that. But now let's move on to our third panelist, Sandeep Kapoor, who is at the cutting edge of building some of these very exciting tools that we're talking about. So Sandeep, you've been an in-house counsel for the better part of your career, but I suppose you found your true passion with what you're doing at the moment. So please take it away.
Sure. Thank you, Nikhil, and thank you, BML Munjal University, for inviting, and thank you, Ritvik, for bringing another such interesting panel where my passion is all about law and technology, how they interface, and I don't know any other. I have a very different view when we say that legal profession is not yet disrupted. Sorry, my data point is very different. We can decide to, ignore the facts and the data which is coming in front of us, the speed at which the disruption is happening, and I will share examples. The second point for, I think Rahul's said a very interesting point for the students who are, currently doing, and, I'm going and spending some time with Amity and a couple of other universities, and this question is on everyone's mind. And I just said them that if you see a life of a lawyer, and I think this point was also touched upon by the panel before us, I always think that our day is divided into three parts. Put it in a paper, it's very simply, it is the knowledge, it is the process, and then it is a lawyering piece, the last piece where, the technicalities or the nitty-gritties of the law has come in. So I think first two pieces today, thanks to the advent of technology, and I can say for every stage that a lawyer has to do, be it research, be it litigation, be it knowledge sharing, there is a technology available to that. Now it is up to us whether we want to learn the technology. I think learning the technology is also a very later stage thing. If you want to just read about the technology, right? For example, when I did my first diligence, thanks to Mr. Rajiv Luthra, for, I was part of Luthra and Luthra. I did my first diligence. We were asked to take flights and trains and go to the client site. And first few days was only, spent in building up the data rooms. And today, when you fast forward, Jagrati already mentioned all-night data room. I'll give you the examples in terms of numbers, how much investment is going on. Because one is the statement we make, other is we back it with the current data, and the best there is data from the world that come in that investment, then the amount of investment is going on in these various setups. I think that entire thing was the premises how algo legal, got formulated. I spent, yes, you're right. I've spent most of the time in-house and, other than 4 to 5 years, initial years in law for practice. What I've seen is a beautiful triangle has emerged over a period of time. When you say triangle, you keep client at the top, you keep service provider, which is a law firm, on the bottom. The third piece to the triangle is these alternate, service legal provider, these ASLPs who are coming up, they are beautifully creating the void of process technology out from the system. Today, in-house counsel, and I'm connected to that community so well, they are demanding. I get so many calls from my in-house counsel. By the way, we are struggling with this piece. Can you tell us a good technology which is there? So what I saw at Sequoia, we worked with more than, Sequoia being so prolific, I've worked more than 3,000 plus transactions over a period of time in Southeast Asia. One common problem was that the standardization of the documents or how we will access the information, even the basic was not standardized. So that one problem, if you see where is algorithm is nothing, it's just a stack of rules which are followed in a logical order. And I feel that law can also be, followed in that. And there is a, Rahul mentioned about artisan pace of law. I'm a big proponent of the science behind the law. We always had as first year student a question whether law is an art or a science. And I think it is both, but today we are talking about more about the scientific principles which are there in law. We have a, the extent and the applicability of the law which defines certain rules. So I saw a huge gap in the market, and in Sequoia in 2017, I got $500,000 to my own entrepreneurship technology. 7 engineers were given to us. And there's a premium. Jagrati can tell you as an in-house, if you get 7 dedicated engineers working at you along with your legal team, it's a premium which you cannot afford to miss. So multiple use cases started to emerge. So as a result, what I saw that why a law firm has to, or any in-house department has to be, only with lawyers, right? What is the mix of the different breed of professionals we can come with? And the first important thing we had to admit was that law can also be decomposed. It can be broken down into various pieces. For example, as we all know, it's not required that for a non-disclosure agreement, you standardize the templates and you have a playbook ready. It has to be dealt by the lawyers, by your paralegals. And again, you don't need those resources now in-house. So a combination of breaking down the processes, in-sourcing, outsourcing, and that's where the model like Ritvik has started, Counsel Select, all these models, when you look at the platform, beautiful platforms are emerging. And I think, yes, it is not fully disrupted, but legal practices are disrupted. All of us are talking about new technologies, right? And what is required to be done is for, students, who are going through the law. Absolutely care. And Rahul made the statement in so many words, and I am emphasizing that. If you think you can come out of the law school and you're worried about your jobs, I'm just saying, please change yourself, adopt to the new technology because times are changing. Now, one question which keeps coming is why lawyers are not adopting technology, right? My question to the technology world is, where is that integrated platform? Jagrati mentioned about the unification of technology. My question is, today when you have to log in for a data room into one product, You have to log out, then you have to go for contract management into another product. Then you come out for your compliances into another product. Why there is a burden on a lawyer to transform itself? Why the technology world is not coming up and giving you an iOS kind of a platform, or a, the Microsoft kind of platform? Because on that platform, sending from my mails, creating my PPTs, working on my Word documents, creating computational analysis, I'm able to do all one shot. We need to make life of people simpler, and that's exactly what I've started coming out. I started the law firm, and I also mentioned I've started my legal technology company also out of Singapore. So the law firm is working very closely with engineers, and to give proof in the pudding that legal tech company is nicely funded by investors. So I don't have to prove that there is a business value, because no investment will come unless they see a business value. And if anyone is giving me $1 million or $2 million, Rahul can tell you, or Ritvik can tell you, they are expecting at least 20 million in the return also. So that means business has to grow, and we are showing how business is growing. Second important piece is that the nature of the work that we do on day-to-day basis, we don't need lawyers at all the time. That does not mean that lawyers jobs. And I can prove you that a first-year lawyer, if he has spent significant time, and I'm just 10% of the entire time in your law curriculum, whether it's 3-year law course or whether it is 5-year law course, if you spend 10% time only in learning technologies and understanding how system work. For example, Luminance has an amazing system for your research, right? You can't just rely on Manu Patra of the world. That is there, but Manu Patra has to go to the next level, where keep research, a computational model, legal research things. Now, what Manu Patra did beautifully, it standardized a platform on which all judgments can be searched with the certain key functions. Now coming the AI technologies, which are picking up, because a lot of questions Manu Patra is also at the back end standardizing. Let's say under Companies Act, section X, what kind of various permutations are coming, that is getting standardized. It will be a problem-based research which is going to come up, which is what Kira for $1,000 is giving you. You want to come up with the probability of the outcome of a litigation that is happening. So the work itself, Nikhil and other panelists, the work is completely getting broken down. That's why in my firm, I realized why laws are not changing, because we are telling beautifully $1 million of investment has happened in technology, go and use it. But they are not going to use it. Their day is equally challenging. So we created a beautiful layer of process design engineers. We have under which there are 7 people attached to 7 teams. They have broken down the usage of technology. They know every stage how a particular process will be working. They have standardized the stack. They have standardized the process. In our firm, everyone talks about, let's say 42.17 means a CV before closing, on a particular thing. We don't talk about clauses. We talk about numbers, and we have given nomenclature to each and every stage of the deal. So that is one piece. And there is tons of investment which is coming in. Like for last 2 years, 2018 has been a point in legal tech industry. As of today, there are more than 1,300 funded companies in the legal tech industry around the world. From 2018 to 19, more than $1 billion worth of investment has gone into all of these companies together. In 2019, 46% more legal tech companies have evolved. Thomson Reuters report, whether you go through that LR report into these things. And when you say legal tech, it starts with the basic standardization of the documents, processing of the documents, compliances, portfolio management, and I can very safely say, and happy to share more data around it, but for every state and every field or subsection of law, whether it is IP, litigation, shipping practice, or anything, this is a technology. Now, whether it is consolidated or unified, answer is no, it is not. That is a challenge. So what we are doing at Algo, we are now developing our own products. There's a first proprietary product which we are coming up thanks to, we are not working only with Quant, which is my legal tech arm. We are working with multiple pieces. Thomson Reuters and announcing our partnership starting next month, where we are working in their product stack and we are changing it. Because product companies, now let's see from a product company's point of view, they also need willingness, domain experts who can come forward and they can share the data and they can start working on making these bridges there. Today, once these bridges are formed, I can see 60-70% is already formed, whether we keep doubting whether the technology will come and disrupt law. I think very soon 100% of these bridges will be built up because of very significant effort has gone in that direction.
Great, Sandeep. Thanks for that. Great insights to know that law firms are already re-engineering themselves from the inside. To be able to integrate more technology into their practices and processes. So now we'll go to Ritvik. Ritvik, earlier today you had shared a lot of insights from the study that Vahura had done in association with BMU. And also you have, through your work, both with Vahura and Agami, very interesting professional experiences with regards to the legal profession. So what are your broad thoughts on how tech is disrupting the legal profession?
So I'll start with the study, and I think what's interesting and what I found out really surprising also is that what Rahul said and Sandeep said and Jagrati, they're all the cutting edge of what they do, and we're seeing, I think, an acknowledgement of this reality now in a much wider spread of the legal profession. And this is not just law firm, not just in-house, but practitioners as well. So one, this entire realization that legal tech is disrupting the profession has moved from the fringe to the mainstream. That's an important acknowledgement for us to kind of look at. Second is, again, taking from what Rahul said, the apprenticeship phase is over. Now the real question is who's going to take that burden or that role. I think clearly with a university like BMU stepping up to say, we will take that role and make law students more ready to kind of enter the profession at year 2, year 3. Wearing my entrepreneurial hat, I think it's a great business model for a number of people listening. It's also a model that can be taken up by a legal entrepreneur. To be honest, we've looked at that model as well ourselves. And third is, what does that mean for a young professional law student? I think that slide that Professor Nigam showed, which is the T-shaped lawyer, where you need to have very strong fundamentals, but you need to also have the other areas that everyone in this panel has spoken about, right? Project management, Jagrati spoke about, using technology, Rahul spoke about, collaboration, team, using systems, Sandeep spoken about. So in a sense, a lot more is going to be expected from a young legal professional today than it was, when any of us kind of came out of law school. But the opportunities are there, and I think new opportunities are also emerging, and that's the good news. Jagrati mentioned the role of legal operations. I can tell you, as someone who recruits, as Vahura recruits across in-house legal teams, that's the role that we've seen now more and more. In our consulting practice now, a lot of what we're talking about, where with in-house legal teams looking to standardize, create playbooks, create process maps, all that is now, a reality in terms of what we do on a day-to-day basis with our consulting practice as well. So I think to summarize, a lot more is expected of young legal professionals. The opportunities are certainly there, but are going to become more and more refined, and new roles are emerging for which one can prepare oneself for. You're on mute, Nikhil. Yeah.
Could you quickly, Ritvik, also take us through a little bit about your experience with ODR? What is happening with online dispute resolution? Especially, I feel like some of these trends have dramatically accelerated with the ongoing pandemic. What does the future look like?
I'll start. I think Rahul mentioned Justice Chandrachud, who is chairing the E-Committee for the Supreme Court, and he had a lecture at NALSA recently where he mentioned some very interesting things. One is the E-Courts Committee. I think they're now moving from phase 2 to phase 3, and it's not just about online hearings and e-hearings, but in addition to what Rahul mentioned earlier, he's also mentioned that they're looking at technology and its role in litigation in a much broader spectrum, which is how can disputes be avoided, how can disputes be resolved, and that brings me to, I think, very exciting developments on the online dispute resolution front. I'll just give a few examples. For example, Sama is one of the ODR platforms that has come out to the Agami challenges. And this is public on Sama's website. In addition to doing work with large banks like ICICI, for the first time, there's going to be an online Lok Adalat, by the Rajasthan Legal Services Authority and Sama. It's going to be on August 8th. So that's a great example of how ODR is being used in a different way. CAMP, the center in Bangalore that I'm associated with, I've also been involved in testing out an online mediation platform as a mediator. And what's really interesting with that is how you can use technology even in an asynchronous way, right? So you can use time itself differently. You don't have to get all parties together, 2 days, just, how that's used is very interesting. Sandeep's firm Algo is incubating, CORD now with a name change. So, very exciting developments there. Samvad, the law firm has, partners whom they have set up. Address Now, again, another online dispute resolution platform. So we're seeing the use cases in different ways: consumer disputes, banking disputes, Lok Adalat, mediation for higher end, for higher value disputes. So a very, very exciting space. There's a Telegram channel that we'll share, I think, for anyone who's interested. For anyone interested in online dispute resolution, that's the group to be part of. And thanks to support from Trilegal and other partners, Agami is trying to, in a very collaborative way, trying to help this entire ecosystem develop.
Great. Thanks so much, Ritvik. So just taking off from some of the things that you just said at the end, and Rahul, we were talking about this yesterday, so I'd like you to come in here, please. And if you could, talk about the shifting of consumer cases from perhaps a local district level or a state level consumer forum to perhaps forums that are built by large platform companies like, for example, e-commerce, Flipkart or Amazon, or perhaps even transportation companies like Ola or Uber, that might take on some of these and deploy bots and technology to resolve these. So please talk a little bit more about that.
Yeah, look, I mean, we clearly are, everyone on this panel has said that we clearly are at a time when disruption either has already happened or is inevitable and is imminent. And so, I'm really keen to use the opportunity to think about some of these problems differently. And so before I pick up on that, and I promise I'll come back to that, I want to pick up something that Ritvik said, which is this opportunity to do things asynchronously. So the wonderful thing about the internet is it is a platform that allows us to communicate asynchronously, which was never possible before that. And so, chats that we do. So this is actually a non-standard way of communicating, the thing we're doing now, which is Zoom, live telecast, where we're all speaking and can hear each other at the same time. The most efficient way to do things is email, where you send a message and it's when I pick it up that I get it. Now, when we have this opportunity to disrupt the legal system, the one thing I hope we don't do is replicate what we do in the offline world online. And which is why I like the comment that Ritvik made, which is this asynchronous dispute resolution, the opportunity to do it asynchronously. And the people who would, as we said, there is friction and there is vested interest to keep the edifice of the law from being disrupted. And my suggestion would be, let's not even try to do that. As a partner in a law firm, my sense, and Jagrati as an in-house counsel will have a much better sense of this, but my sense is not even 5% of disputes actually come to court. I would say maybe 1% of disputes come to court. 99% of disputes, and of the 99%, maybe 3% will come to us as external legal counsel, but the remaining disputes are sorted out internally. You have internal mechanisms whereby when your vendor has an issue, you find a way to sort it out. Now, just because you sorted it out doesn't mean it's not a dispute. Sometimes when you sort it out, because it's an inefficient method, you leave money on the table or people leave that place being disappointed. So if you can create an ODR mechanism that leverages the online platform, uses things like time shifting, uses the advantage that you don't all have to be physically in the courtroom at the same time, you have an opportunity to actually surface things which are currently not being surfaced as a dispute, and resolving them with the rigor of a dispute resolution, which actually leaves the people, both parties to that dispute, a lot more satisfied. And at the end of the day, the reason why we need to resolve disputes in this sort of a manner is because all disputes come up in the course of a relationship. And if you don't resolve it properly, if you leave money on the table, if you say, I'll never work with this person again, you've destroyed the relationship, which is not a productive use of the processes that we have built. So that's the really interesting thing for me. And I think that a lot of this disruption is going to happen in companies like Flipkart, Amazon, Ola, Uber, where there are high volume, low ticket disputes. You'll be really upset that the Ola driver didn't show up, or the Swiggy delivery guy, called you from the shop and said, look, I'm sorry, but I don't feel like coming today because it's raining. Because, he's wasted half an hour of your time. But the process of taking him to the consumer court is just not worth the 45 rupees you paid for him to go to the shop and bring it. Now, if you have an ODR mechanism that is efficient, that allows the dispute to be resolved in a dispute resolution way, not Swiggy standing up and saying, look, I'm going to pay you the 45 because I want to keep you as a customer. Swiggy's not happy with it. Swiggy's not going to keep doing this forever. Is there a way in which we can use these things that Ritvik is working on with Agami? I think all of these sorts of solutions that perhaps Justice Chandrachud is thinking about at a very high level in the Supreme Court, but is actually most important down at that level where it's not even a dispute. If we can use this, and if our students can start to understand that this is the future of law, we're going to create different jobs, different skills, and we're going to actually, radically transform the way in which the practice of law exists today.
Thanks, Val. So we're running dangerously close to the finishing time. So I quickly want to go over to Jagriti and Sandeep if you all want to come in on what Rahul has just said. So Jagriti, if you could give us some insight from your vantage point on how many disputes actually reach the courts these days.
Rahul was absolutely right. I think the first effort is trying to solve it at our end, because the cost-benefit ratio of anything going to court is detrimental to both parties. So nobody really wants to go through the court process unless it's something that absolutely cannot be sorted out. I would think that banks have far more disputes that will automatically go to court. So, a check bouncing and things like that, and loans not being paid. But for most other organizations, most other commercial transactions, finally end up in being determined according to how much money is there to lose, and the relationship, of course. And so while the lawyers will advise on what the options are, business plays a critical role in evaluating the commercial relationship and the commercial value that's at stake. So in my experience, very little goes to court from corporates, from organizations. And the more, like what Rahul said, even if you have a dispute with Swiggy, you're not going to go to court for it. So yeah, alternate dispute resolution mechanisms definitely are the need of the day.
Thanks, Jagriti. Sandeep, if you'd like to quickly take a crack at that with your own experience as an in-house counsel.
Yeah, so I think I completely agree with Rahul and Jagriti, but what is also very interestingly happening is a lot of knowledge and data science is coming out with respect to the disputes which have already got solved. I think what will be very interesting point is when because CRT, which we have been incubating, and Agami, Sama, and others, when they create their own small, knowledge center where we can say, how legal costs work and how the dispute got solved. And when you look at, let's say, 1,000 disputes which got solved through these panels, and what is the net benefit coming? I think that's our duty to go back to the budding students or the fellow lawyers or the legal community at large, that this is the data science behind it. My biggest worry is that we are making all these initiatives, but some of these initiatives are not talking to each other. I think the collaboration, which is the theme world over right now, especially in pandemic time, I think we need to create these knowledge banks, and these pieces cannot work in isolation. I keep telling CRT people that please let's talk to Ritvik, bring them on board. Let's talk to other litigation firm. Komal from CAM, who is their chief innovation officer, I'm in touch with her. They have very interesting incubation strategy going on, and we keep exchanging knowledge. I think this knowledge exchange is very, very important. Only other piece I'd like to bring in, Kotak Mahindra Bank, the fintech sector which is coming up, right? The money taps of the world who are giving this credit cards of the world, the payments, there this dispute mechanism is working like beautifully. For example, for a outstanding of 5 lakh rupees, Kotak has only a limitation in the legal budget of 2,000 rupees per dispute. So here is the mechanism which is coming end to end, whether it is whatever is the process being done, 1,000 cases to be solved in this case, but it requires a different kind of training to the ecosystem. The mediators, creating those kind of trainings, creating the capacities, and for judges to come forward and say this is an excellent thing. I highly recommend everyone to follow Professor Richard Susskind blindly. The latest book, Online Dispute Resolution, is a very, very thought-provoking book. It's already, he started changing all of us in 2012 by saying tomorrow's lawyers are going to be coming to an end. And now he's saying an online dispute resolution, and some of the examples and use cases which are emerging. And the only last point I will make, Nikhil, the collaboration is not limited in Bangalore, in India. Collaboration is happening across the world. I get one inbound from law firm in Norway, in Sweden, saying, oh, we scanned, you are a algo legal, you are trying to disrupt technologies. What is your use case? We are looking for this product. Have you already looked into the product? What is your strategy? What are the cost benefit? I think this collaboration is a theme which has to emerge. And if we keep disrupting ourselves and we are not happy to come forward and share knowledge and data science about it, and if we are just disrupting and we don't have a reporting mechanism as a final outcome, and we don't discuss between the innovation team, I think somewhere the discussion will get lost into small pockets. That should also be a very strong point we need to guard together.
Great. Thanks so much, Sandeep. I think we're almost out of time. I'm not sure how much further this can go on, but Ritvik, if you'd like to quickly, Sandeep already mentioned about a lot of legal tech startups taking the funding route, and many more opportunities emerging on that end of the spectrum. And to my mind, as somebody who's been in the media space, which has been repeatedly disrupted over several decades, can you talk a little bit about what it looks like, what do deals look like, and perhaps young lawyers ought to think about working more with different sorts of professionals rather than just among themselves?
Yeah, and I think it's not. So I think funding is one signal of how the ecosystem is growing. So I'll use a few data points. One is again coming back to Agami and the Agami Prize. The first one 2 years ago in 2018, we got 184 applications, and this is not only legal tech; it's also citizenship. So broadly legal innovation. And Sandeep, and if you go to the Algo site, there's a wonderful report that they have on the legal tech ecosystem. But I think by our estimates, there are about 200 to 250 active legal tech companies in India. Very few will be funded, maybe about 10%, we're seeing a lot of early stage funding as well, angel funding, Mumbai Angels, IAN, much more active. Sandeep's own venture, I think in Singapore, he's raised money we can talk about. But I think what we're seeing is the ecosystem is now very vibrant. We're seeing kind of recruitment of people, now definitely full-time founders are the default and not part-time founders, which is one signal of maturity. Mixed founding teams, engineers and lawyers, pure engineers coming together. So it's a very interesting space, and again another job opportunity for young lawyers that want to take a different path.
I'll just add on, Nikhil, if you permit. The quick interesting thing which is happening is there are dedicated funds coming up for Next Law Venture is $1 billion fund out of California invested in 26 different legal tech companies. law firms, Clifford Chance, Denton, Freshfields, they have their own, strategic funds, which they are coming up. Algo is starting its own AIF very soon, based on some more, data points we are collecting, which wants to, nurture some of these things together. So it's a beautiful field, and I think to change the seed in the mind of the law student that coming out in law firm and in-house, there are so many other fields which are coming up. Today, some of the lawyers are becoming financial analysts. Sirion Labs, which is Sequoia's company with 200 million valuation, the CTO is a lawyer from Cambridge University. He did his law, then he went and he did his technology. He's the chief technology officer for Sirion Labs in US. So it's a beautiful example coming up in investment world.
Great. Thank you for that, Sandeep. And thanks to each of you, Rahul, Ritvik, Jagriti, and Sandeep. I think it's a wonderful combination of ideas that we've had. We started off with a rather dystopian view of the world, with a lot of, scaring perhaps a lot of our younger members of the audience, saying, you're not going to have jobs when you leave law school. But then we're ending on a very positive note with, we're talking, with investors putting their money where their mouth is, literally, and, coming up with, funding legal tech startups and opportunities in legal innovation. So it's a wonderful, that's the bright side to all this. Again, I'd like to thank each of you, as well as the BML Munjal University, as well as Vahura, for putting this panel together and having all of us. Please don't go anywhere. I'm told we have a very exciting speaker coming up next, who's going to zoom out and look at how the rest of society perhaps looks at law, the legal profession, and the justice system. So please stay tuned for that. And thanks again for being here.
Thanks, Nikhil. Thank you, everyone.
Thank you. Thank you, everyone.
Thank you.
Thank you to all the panelists and to Nikhil for moderating this discussion. The session gave us insights as to how the future lawyers will need to upgrade their technological skills to excel in this digital age. I once again thank all the panelists and the moderator. This has indeed been a delightful day with such enriching conversations. To further add to it, we have with us Ms. Faye D'Souza. Allow me the honor to introduce her. Ms. Faye D'Souza is an award-winning journalist who has changed the way news has covered on Indian televisions by focusing the audience's attention on the issues that matter to the citizens, rather than those that fuel the emotions of partisan debates. Faye's calm, research style of hosting news shows prioritizes information over opinion. Her focus on accountability of government, responsible taxation, safety of women and children, education, health, and urban development has also resulted in several policy changes that have proven that a journalist can still bring about improvements in the status quo. Faye is the journalist of the millennials, young, fresh, and brutally honest. Faye was the youngest woman journalist in India to have led a national news channel as its executive editor. Post her exit from television, Faye has begun her entrepreneurial journey and will soon launch her new own digital news platform targeted at the young, urban Indian audience. I now invite Ms. Faye D'Souza to present the concluding note of the conclave. Over to you, Faye.
Thank you so much. I'm actually really pleased to be here. So first of all, good afternoon to the entire faculty, students, Professor Dr. Nigam, and the team at Vahura. Thank you so much for inviting me. It's a pleasure to be here. I'm a little intimidated hearing everyone who's spoken before me, because I'm neither a lawyer nor a professor. So I guess I'm bringing in an entirely layperson's point of view to the question of decoding the next gen legal professional. This is, I guess, we could say, a citizen point of view, as a citizen of our democracy, what we hope for from the young bright minds who will be our legal professionals in the future. I want to start by telling you a story, because this is what we do, like as journalists, we tell you stories. And this is a story you've already heard, but I do promise you that the story is entirely factual, as opposed to some others who might be telling stories with some extent of fiction. And maybe next time Vahura could do a full day on next generation media professionals, and we'll remind them that journalism is necessarily in the non-fiction category. But let me set that aside. The story that I want to tell you is from December last year. And this was the case in Telangana. And it has been talked about a great deal since then. And I'm sure you remember it. A young veterinarian woman was raped and murdered right at the outskirts of Hyderabad by four men allegedly, and the police apparently took the accused into custody. Now, the country was horrified, quite rightly, with this rape, and we normally are horrified when crime comes into the middle class, when little less moved when it happens in our villages to Dalit and tribal women on a daily basis. But when it comes into the middle class, then national media picks it up and it becomes, a subject of debate at every dinner table and on social media. Now, in this case, the track record of the case told us that the police had really messed up, and to cover up their own inadequacy and failure, because the family had gone to the police when they realized that this woman was missing, and the police didn't file the case, and they wasted precious hours. And in order to cover up that inadequacy, the police then took these four accused and said that there was an encounter. And I'm putting the word encounter into inverted commas because an encounter is supposed to happen by accident, but it happens rather often these days. And the justification given by the police of how this encounter took place was so weak that an 11-year-old child reading Nancy Drew novels would be able to poke holes into that story. It was the weakest, perhaps, encounter story the police has put together after Vikas Dubey. But that's not the real point of why I'm telling you this. What happened after that is the real shocker. Now, the very police who should have really been hauled up for not filing the complaint, for not listening to the parents of this young lady, for not looking for her, and for not literally saving her life, they suddenly became national heroes. They were being garlanded, they were being fed laddus, and people were making a really big deal out of them. It was like this amazing way to clean up the stains from your uniform. It was like a Tide ad where suddenly whoosh, and these guys were heroes instead of people who failed to do their job. And I remember at that time, I was a freshly minted unemployed individual. It was this December last year. And I was within the non-compete period of my former employer. So I couldn't actually say anything on media, but I could put out a video on my own Facebook, which is what I did. And I listed the reasons why I believed what the police had done was at best questionable and at worst very scary and illegal. And as you can guess, a small army of the country's conscience keepers landed up on that post, and they started calling names, and there was a lot of trolling. They said I didn't have sympathy. One chap actually said that you don't understand how girls feel. You should be raped, then you will understand. So here was an individual who claimed to be a champion to the cause of all women, who suggested rape as a route to develop empathy. And while he was an extreme case, even the most moderate opinions on this case were very concerning, because it was about what is the point? If they had taken it to court, the trial would have gone on forever. Look at the Nirbhaya case. This is still dragging on after so many years. It just goes on and on for so long. This is much faster. This is much better for the family. And that actually raises many questions. And a lot of the references after the Hyderabad case were about Nirbhaya, because it was said that the Nirbhaya case had political and media glare on it the entire time. There was a political will, if you were, to get things done. The family stayed on top of it and spoke to the press and kept the pressure on, and still it took years and years and years. And so a lot of people were like, what is the point of going through this system if it's going to take that long? And that opinion turned into an endorsement of the police action. And if the citizens felt that Telangana was in some way justified, they were even more pleased with the encounter of Vikas Dubey, the Don of Kanpur, which is a far more recent case. And I'm not going to tell that story again because you're familiar with that story, but consider the fact that most of the argument around Dubey was not the fact that the legal system had been bypassed and that the process had not been seen through, but it was about, he didn't get a chance to tell his story and sort of out the political powers who might have been associated with him. And I was a little concerned in the Vikas Dubey case that there wasn't enough worry from media, from those who were writing about it, or from general citizens that the entire legal system was being bypassed. And the police had just appointed itself executioner in that case. Of course, I must point out that that is still, to be investigated and ascertained. But I suppose everyone sort of saw through all of the gaps in the police's story on that day as well. Where does that leave us as citizens today? And where does that leave you as the next generation of legal professionals? I think that the fear of the common Indian of the courts, of getting stuck in the court system and the long drawn out court process is well documented in our pop culture. There is the very famous Tariq pe Tariq dialogue of Sunny Deol. There's this whole court kacheri ki chakkar mein kyun fasna? Mishra ji, let's like not do this, right? So the idea of a regular citizen of two places that they're really afraid of is the police station, which nobody wants to go to, and the courts that nobody wants to get stuck in. And that is perhaps, if we sit back and think about it, these are two places where you should be assured safety, where you should be assured a careful hearing of your pain, and you should be assured justice. And these are the two places that the average citizen doesn't want to go, the police station and the courtroom. And that perhaps needs to bring us to ask ourselves, then what's going on? How do we get to this point? And I do understand that pendency has been a problem for a very long time, but it just feels like right now it has become a much bigger problem. I worry about the fact that police action being endorsed by citizens has now also perhaps received the blessing of governments. We have governments that are bragging about how many encounters that they have done and how they have delivered law and order to citizens through this encounter process. And one wonders how that works really, and if the encounter process is something that's acceptable to civil society. What is stopping the police from turning into a mob that just picks up random citizens, extorts them, shoots people, almost becomes a sort of mafia extension to get the job done, a supari extension to get the job done. I'm not saying it's happened already, but there is this wide now gaping hole in our system where it could happen. And that is something that we should really worry about. And if it all then winds down, and I'm oversimplifying this really, if it winds down to pendency, and if on last check, I think we have over 3.5 crore cases pending in India. If we are going to oversimplify it and say, okay, this is the problem, let's focus with blinkers on this problem. How do we fix this problem? I mean, on one hand, you have millions and millions of families waiting for justice. You have millions and millions of under trial people languishing in prisons all over the country. The pressure on the system is unbelievable. And I think that pressure has not been more apparent than in the lockdown, where the courts could only hear what was urgent and the pileup just increased exponentially. I mean, consider the fact that everything from a traffic violation to gang rape to murder to UAPA, everything is waiting in this pileup right now. Plus tribunals, plus commissions, plus disputes, all of these things. And I don't have to tell you because you know this stuff better than me. Where are the solutions? In fact, Justice Madan B. Lokar, the former judge of the Supreme Court, in a recent column that he wrote for Outlook magazine has said, and I'm quoting carefully, this humongous caseload is the cause of delays, adjournments, and frustration among litigants who suffer the slings and arrows of outrageous misfortune. Remedial measures are absolutely necessary, and without them, the frustration might turn into anger, which will be followed by doomsday. End quote. Now, I'm not sure about doomsday, but I think that we can already see the police turning into a parallel system. We can see the lack of faith, and we can see civil society sort of looking for faster routes to feel better. And that invariably turns into bloodlust. And that then becomes a really scary thing, because if I understand correctly, jurisprudence is not about revenge. It's about reform. It's about prevention. So we wind up then missing the dots or unable to join the dots on several of these things. During the lockdown, as a journalist, the number of cases that came up of police excess and brutality, starting with the random beating up of anybody who was on the street, the throwing of vegetables on the road, up to the deaths of the father and son in Tuticorin who were arrested for keeping their shops open, it sort of gave us the sense that the police has become bigger than the space that it really had in our system, or the space that it's meant to have in our system. And there's a reason why I'm bringing this up today in this conference with this audience, because I believe that and I was listening to you talk about in the previous session about different kinds of lawyers and the different kinds of roles you play within business, within, within the legal system. I believe that it is time for all of these people, including those in universities, including those training to be lawyers, to start considering how we can solve this problem. Because really solving this problem is at this point building a stronger system for students to inherit. And if we don't right now put all of our, all of our faculties and pour all of our attention into solving this problem, our students who will graduate in the next few years will inherit an even more broken system, and that will be even worse. I want to quote again Deepak Mishra, the former Chief Justice of India, and he in 2018 addressed a national conference on the initiatives to reduce pendency and delays in the judicial system. And he talked about technology, and he highlighted that he believed that the key is really in case management. And he talked about the use of technology, and I'm going to just quickly take you through what he talked about. He said, one, to monitor use of technology to monitor the progress on cases based on urgency and the type of case. 2, time limits to dispose certain types of cases. 3, not to allow dilution of statutory prescribed timelines and guidelines for adjournment. 4, to understand why some courts perform better despite the shortage of judges and adopt these courts as role models. And 5, committees at high court levels to be more proactive and functional. And Justice Mishra himself in this speech noted that technology can do wonders if used wisely as well as appropriately. So my point to you as students, as faculty, as members of the legal fraternity is this: is it possible? And we know young people tend to understand technology better than those of us who are more experienced. So is it possible to use students who are studying law and young people to find ways to bring technological innovations to this process? Is it possible to use time spent in universities, not just in learning the law, but also in trying to find solutions for it? Because obviously, as young people, you have fresh eyes on the problem. You have a keener understanding of technology. You're more familiar with the possibilities of technology, as opposed to a system that tends to be a little more reluctant to change. What can you do to make this better? I mean, obviously we can't solve the problem overnight, but what can be done to make this even slightly better for the families who are waiting for justice, for the under trials who are waiting for some sort of breakthrough, for courts, for clerks, for prosecutors, for legal talent, and for yourself, so that you graduate into a world that is more efficient, if not less hopeless. And secondly, the other point I'd like to put forward to this group of people is the possibility of universities like this one to harness talent and the wealth of knowledge that you have among your faculty and among your students to aid in the process of lawmaking. And I find this again, and I keep going back to these cases because these are the ones that we track the most. Whenever there is a case of aggravated sexual assault or POCSO, and it's a really heinous crime of rape, all the lawmakers across the country start crying for the death penalty to be delivered even faster. And people cheer and the media cheers and say, yeah, this is what needs to be done. But every time that happens, there is a group of legal minds who very quietly say, this is not going to do the job. This is not the solution. This is not what is needed. And they have the research that proves it. They have the insight that proves it. They have all of the data that's necessary in order to make these decisions. But somehow these two, there's a massive gap between the people who know what needs to be done and the people who are actually doing it. Is it possible for our universities as so bipartisan spaces of learning, spaces of learning to offer our lawmakers research, insight, understanding in what is really needed? And there are many, many matters on which India has not really found answers. Matters of capital punishment, for example, which we continue to debate, how juvenile related crime needs to be dealt with, crimes against women, an understanding of why rape happens, how to stop it, how to protect children, how to protect the more vulnerable sections of our society. The understanding, for example, on caste laws and prevention of atrocities. Studies that will actually be able to empower our lawmakers to be able to write better laws that then can be enforced better laws that actually lead to a stronger society. Is it possible for universities like this and young people and professionals like you to join the dots between executive and legislature and actually empower society in laws that actually take us forward and achieve what was meant to be achieved by our constitution? Again, like I said at the beginning, I'm bringing in the layperson's point of view. I'm not a lawyer, but this is really what one would hope for. I've always been an optimist and an idealist, but this is really the world I would hope for. And this is my submission to you today, that if we are going to talk about how we can be better professionals, if we're going to talk about how we can all work towards a better system, a better legal system, a better system that's more efficient, then can we also consider ways to reduce pendency? Thank you.
Thank you, Faye, for your concluding remarks. It was wonderful to hear your thoughts and insights on the evolving legal space in India. And I must say that we as lawyers, academicians, or probably law school, you've given us a lot of points to work on. Thank you so much. We've now come to the end of the conclave. We hope you enjoyed the session as much as we did having you over. We look forward to such engaging sessions in the future. On behalf of BML Munjal University and Vahura, I, Dr. Kavita Chawla, would like to thank each one of our speakers, our dignitaries, guests, colleagues, and friends from the legal fraternity for having been with us today. Should you have any questions or feedback, please feel free to write back to us on our official email ID, lawconclave2020feedback@bmu.edu.in. The report will be emailed to your registered ID. Thank you once more. Stay safe, stay connected. Until next time, goodbye.